Good morning.
Good morning.
I'm Carlton W. Reeves, the chair of the United States Sentencing Commission. I welcome you all to our third day of hearings on our current slate of proposed amendments to the sentencing guidelines. I thank each of you for joining us, whether you're with us in this room or attending via live stream. We appreciate your interest in the work of your United States Sentencing Commission. I have the honor of opening this hearing with my fellow commissioners. To my right, we have Vice Chair Claire Murray, Vice Chair Laura Mate, and Commissioner Claria Boone, and ex officio Commissioner Jonathan Wroblewski. To my left, we have Vice Chair Luis Felipe Restrepo and Commissioner Candace Wong. We're also have Commissioner John Gleason, who's attending by phone, but he's with us today, and we appreciate his presence in that capacity. I must begin by noting the diligence, dedication, and contributions of every member of the Commission's staff. Their work is hard, their work is indispensable, and their work is extraordinarily appreciated by each of the commissioners. I speak on behalf of the commissioners and the public when I say to our employees, thank you for all you have done, all you are doing, and all that you will continue to do. I want to welcome our esteemed panelists today. They've come from across the country to provide us with their testimony. In doing so, they join the over 2,000 people who have already submitted comments to the commission. At our last hearing, I made a promise. When you speak to the commission, you will be heard. I'm happy to report that we at the commission have kept that promise. When we have read carefully researched written comments, we have been persuaded. When we have heard testimony grounded in lived experience, we have indeed been moved. And when we deliberate, we find ourselves constantly citing what panelists and commentators have told us. If you have spoken to this commission, I can say for a fact, you have been heard. And so I remind our panelists and the public, you will be heard because you must be heard. Commissioners and our staff are committed to doing our jobs in our criminal justice system with a focus on that word justice. But we can't do justice without your data. We can't do justice without your expertise. We can't do justice without your perspectives. While our hearings may be ending this week, our need for your input is not. We will continue to accept public comments until March 14th. Panelists, if you come away from today with more to say, please provide us with supplemental testimony before the deadline. I also urge members of the public to submit comments via our online portal at www.ussc.gov. However, and whenever you speak to the commission, you will be heard. Today, we will be hearing testimony on proposed amendments regarding firearms offenses, drug offenses, and resolving conflicts among the courts of appeals. Tomorrow, we will be taking testimony on proposed amendments regarding the career offender guideline and how criminal history is addressed in the guidelines. Panelists, you will each have 5 minutes to speak. Know that we have read your written submissions. Your time will begin when the light turns green. You have 1 minute left when it turns yellow, and no time left when it turns red. If I cut you off, please understand I'm not being rude, as we have so much to cover today and tomorrow and a limited time to hear from everyone. For our audio system to work, you will need to make sure that your microphone is on before speaking. Look for a little green light. You'll also need to speak close to the microphone, and I mean close, inches, not feet. You need to speak close and into the microphone. When all the panelists have finished speaking, the commissioners may ask you questions. I'm certain they will do so. Thank you for joining us, and I look forward to a very productive hearing. But before I introduce this panel, I like to take a point of personal privilege. See, they don't know. This is my own stuff. At our initial hearing the other week, for those who know me, I always find a way to mention my hometown, Yazoo City. And I mentioned at the last meeting that we had two members from my community who were on the NFC championship team there. Well, here I go again. Last week, Yazoo City High School boys basketball team, they were in the semifinal round of the state championship in basketball. And after they won that game last Monday night, Tuesday morning, a week ago today, I get a call from a grandparent from one of the players. She said, Judge, it would be real nice if we could get our students, if they win the championship, to the White House. You know President Biden. I said, well, she said, they do it for the NBA teams. They do it for the colleges. Why not? Well, I'm proud to report that they did win the championship a few days later. I cannot guarantee that they'll be invited to the White House, but I'm giving them a shout out here today, the 4A champions of the state of Mississippi. The coach, Anthony Carlisle, and the boys at Yazoo City, a place which also is the home to one of its largest employers is actually FCC Yazoo City, Federal Correctional Complex. And it's amazing what Coach Carlisle, Anthony Carlisle, has done for the spirit of that community with these young men in that community. Between he and his father, they bring home 13 baker dozens of gold balls, state championships. And it's good to bring so much life, so much inspiration into that small hometown. So I congratulate the boys at Yazoo City High School on their 4A championship, and thank you, Coach Anthony Carlisle, for your inspiration. Now, having said that, I'd like to introduce the first panel. Our first panelist will present the executive branch's perspective on our proposed amendment on firearms offenses. We have with us the Honorable Gary Restaino, who currently serves as United States Attorney for the District of Arizona. Mr. Restaino currently serves on the Attorney General's Advisory Committee, where he elevates the voices of U.S. attorneys in the Department of Justice policies. Mr. Restaino has previously served as acting director of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, and as an assistant United States attorney. Before beginning federal service, Mr. Restaino was a civil rights lawyer with the Arizona Attorney General's office. Mr. Restaino, we're ready when you are, sir.
Thank you, Chair Reeves and the commissioners. There's no higher priority at the Department of Justice than keeping our communities safe from violent crime, particularly gun violence. In response to the rise in gun violence during the pandemic, the department issued a comprehensive violent crime reduction strategy that focuses our enforcement efforts on the most serious drivers of violent crime in each community. The Bipartisan Safer Communities Act, or BISCA, has aided our efforts through new enforcement tools as well as intervention programs aimed at preventing violence before it occurs. In BISCA, Congress also created sentencing directives to the Commission, and the Department appreciates this opportunity to speak about those directives, as well as other ways to help make the firearm guideline more tailored and effective. The Department supports expedited and effective implementation of BISCA's directive to increase sentences for straw purchasers and traffickers to reflect the danger their conduct poses to public safety. Yet maintaining the existing parity between these offenders and prohibited possessors of firearms is also critically important. Otherwise, a felon who asks a straw purchaser to procure a gun for him could face a lower guideline range than the purchaser. Congress demonstrated its commitment to parity in BISCA when it raised the statutory maximum from prohibited persons to the same as for straw purchasers, and treating them differently in the guidelines would be inconsistent with that demonstrated intent for parity. Second, the offense level for all aggravated straw purchasing offenses should be increased, not just those with the statutory maximum of 15 years in prison. Currently, the guidelines treat all straw purchaser offenses with knowledge of future criminal possession the same. Congress instructed the Commission to ensure increased penalties not only for BISCA's new straw purchaser offenses, but also other offenses applicable to the straw purchases, a category that, as the Commission itself has repeatedly recognized, includes false statement offenses when committed with this heightened knowledge. Third, the Department requests a larger offense level increase for these aggravated straw purchasers rather than the proposed 1 to 2 level increase. Because straw purchasers generally have no criminal history, such a minor increase will often result in a range only 1 month higher than the existing guidelines, which the Department contends is inconsistent with Congress's directive. Fourth, the Department agrees that a mitigating factor reduction is appropriate for a subset of straw purchasers. As potentially drafted, the criteria framed in the disjunctive is overly broad and will result in most straw purchasers qualifying for the reduction. This would wipe out the sentencing increase mandated by BISCA and lead to anomalous results. The Department's letter sets forth several examples, including a reduction for a gang member who knows that the firearm would be used to further criminal activity when the offense is motivated by gang loyalty rather than direct compensation. The Department supports the criteria but recommends that the Commission adopt the conjunctive formulation. The Department appreciates the Commission's proposal for a 4-level enhancement when the offense involves a firearm with no serial number, also known as a ghost gun. Serial numbers are necessary to trace firearms used in crime, a critical investigative tool. Recent data indicates that criminals are increasingly using ghost guns to commit crime. A couple years ago, for example, more than 20,000 ghost guns were recovered by law enforcement in criminal investigations, a 10-fold increase from 2016. The Commission's proposed amendment would close the gap in the current enhancement, which applies only to firearms with altered or obliterated serial numbers. The Department also appreciates the Commission's concerns about the mens rea requirement for this enhancement, and it recommends the Commission create a rebuttable mens rea presumption. The Department also strongly recommends updating Section 2K 2.1's definition of a firearm. The current definition lacks cross-references to relevant statutory and regulatory authority, which has 2 significant consequences. First, under the current definition, machine gun conversion devices, those that turn semi-automatic guns into illegal machine guns, don't qualify for trafficking or number of firearms enhancements. Second, part kits used to readily assemble ghost guns likewise don't trigger these enhancements. So given the rising popularity of these dangerous devices amongst violent offenders, an update to comport with existing federal law is critical. Finally, the Department encourages the Commission to address the significant gaps in the existing recidivism penalties. For nearly 30 years, Congress has recognized that individuals who possess a firearm after a misdemeanor domestic violence conviction pose a public danger. They should be treated the same as an offender with a prior felony crime of violence or controlled substance conviction. As courts have recognized, Congress enacted Section 922G9 precisely because existing felon in possession laws were not keeping firearms out of the hands of domestic abusers. In the past year, Congress has reaffirmed the importance of deterring domestic violence, both through the BISCA and the reauthorization of VAWA, and the guidelines should similarly treat misdemeanor crimes of domestic violence the same as other crimes. The current guideline also lacks a recidivism enhancement for many prior firearm offenses, such as being a prohibited person in possession of a firearm, and the Commission's own data demonstrates that this population's high rate of recidivism poses a danger to the public. Thank you, and I'd be happy to answer any questions of the Commissioners.
Thank you, Mr. Restaino. He says he's happy to hear questions, so I turn to my colleagues. Who wishes to go first?
So your colleagues on the other side of the argument have suggested that doing what you're asking us to do might result in some racial disparities. Has the department thought about that?
We have, Judge Restrepo, and I do appreciate the opportunity to speak about this, both in terms of the racial disparities that are possible with respect to defendants in firearms cases, but also with respect to the racial disparities in communities impacted by gun violence. And so I'd like to address this by talking about the Project Safe Neighborhoods program, as well as the data-driven efforts to predicate investigations moving forward. We don't talk enough about Project Safe Neighborhoods. It's one of the best things that we do in the department. It is an effort to combine focused enforcement with community outreach, because we as prosecutors need to get out of the courthouse and into the communities that surround it. This program's been around for a long time. When I started as a young prosecutor, it was mostly enforcement, a little bit of outreach. I remember giving out trigger lock devices. It's really come a long way, and it's been amplified by the Attorney General's Equity Action Plan for Underserved Communities and the Deputy Attorney General's Comprehensive Strategy on gun violence. And really, it operates in a couple of different ways. It's focused enforcement on the drivers of violent crime in a community, but it's also engaging with those community members through a reinvigorated community relations service, through listening to the community, through, in some cases, academic surveys. When I came on as U.S. Attorney in Arizona, I was able to look at the surveys from our academic partners to communities impacted by violence. They certainly have suggestions for us, like give us more transparency. None of those surveys said get out of our communities. And so we take that as a sign that this is an approach that communities impacted by gun violence, which are often communities of color, are appreciative of the efforts that are being done. Moving on to the enforcement, we are predicating more investigations based on objective criteria rather than traffic stops and the like. The Commission's own data suggests that a little more than a quarter of the cases are traffic stops, which can have a racial disparity. I'd like to talk about the 75% that are really predicated on something else. From my time at ATF, I know the importance of the data-driven efforts to predicate investigations. E-trace and tracing firearms is critical to telling the story of that particular gun. When it left the regulated stream of commerce from a federally licensed firearms dealer, where it wound up at a crime scene, and what other guns were purchased by the same purchaser to show the commonality. It also involves efforts through NIBIN, the National Integrated Ballistics Information Network, which shows the fingerprint of that firearm and the other casings that were ejected from that firearm at various crime scenes as a way of tying together various crimes. What this shows us is an objective effort to go into the communities where gun violence is being impacted and where it's taking place. Our local partners as well follow along on this. I was in a meeting in Tucson a couple weeks ago where they were talking about acoustic devices, shot spotters, to detect where shots are being fired in communities, because that too is an indicator of which communities need our efforts. Finally, there are efforts to work with trauma centers and local law enforcement to get better reporting on non-fatal shooting incidents in order to drive that as an investigative strategy. Now, are all of these efforts going to completely eliminate racial disparity? We don't know. They are efforts, though, to engage in objective, data-driven policing. We encourage the Commission to adopt the amendments expeditiously, and then for the excellent Commission staff to study its impact in the future.
Mr. Restaino, thanks. Restaino, thanks so much for being here and for your testimony. I had a question about the department's suggestion that we increase or we include an enhancement for federal firearms licensees, and I'm wondering why you don't think that those, thefts in the context of federal firearms licensees are already well accounted for in the guidelines by, for example, the enhancements for numbers of firearms, stolen firearms, proximity to high-capacity magazines. Why do we need a special enhancement for federal firearms licensees?
So we agree that some of the enhancements can be impacted on a 922U conviction for a theft or burglary from an offense. We disagree with the probation officer's statement that stolen firearms are included because of the commentary in the guidelines that exclude stolen firearms from 922U offenses. We do think that a greater enhancement is important to take into account what's going on here. It's not just thefts from federally licensed firearms dealers. It can be burglaries as well. There is anecdotal support in terms of recent cases without strong data to support what this means as a trend, but anecdotal support that people are in some jurisdictions driving trucks and vehicles into the sides of federally licensed firearm dealers to get inside and take those firearms. That's different than a theft offense. Right now, 922U is categorized as more of a regulatory offense in the guidelines with where it is, and we think offense-level conduct and what is typically happening should be supported and should support a greater increase.
Mr.
Yeah,
Strickland.
with respect to the domestic violence enhancement, or considering those misdemeanors predicates, I'm sure you're aware of this Fifth Circuit opinion in light of the Bruin decision, where the Fifth Circuit took the position that that was unconstitutional, to deprive this individual of his gun rights. Should we wait and see how that plays out before we move forward on that particular issue?
The department certainly encourages the commission to move forward on whatever it can move forward on expeditiously. As to that specific one, Judge, we don't yet know how Bruin is going to shake out, but we do expect that the commission should take into account current law and should take into account the importance of domestic violence misdemeanor convictions. So we would still encourage the commission to move forward with an amendment on this. The department's letter contains just the massive amount of danger that domestic violence creates for the community and for victims. And certainly with the passage not only of BISCA, but of wonderful VAWA reauthorization amendments as well, the time really is ripe to get a greater increase for the domestic violence, given how much of a driver it is into the local communities for violence.
Thanks.
I have a technical question about the machine gun proposal that the department made with respect to the definition of firearms. So when you have a firearm that's outfitted with a Glock converter switch, the switch itself is classified as a machine gun, as well as the firearm with that switch together could be considered a machine gun. So if the definition of firearm is expanded and tethered to that definition of 5845A, if you have a firearm outfitted with a switch, does that count as two firearms, or would that be one?
Hadn't really thought about that particular question. I think I would defer for the department to get back to you if we have any further guidance. My gut sense as a prosecutor is that's going to be one firearm. That what we would be looking at there is one firearm with the combined devices, but it's still critical to get the 5845 definition under the National Firearms Act, because otherwise we're just dealing with a Gun Control Act definition within the guidelines.
So maybe I missed it, but does the department have commentary or advice on the gang enhancement definition? I didn't see that in the letter.
The department does support the gang enhancement. That is in the department. It's a little bit more than just gangs. It's more of a enterprise scenario, and the department supports the increase with respect to that.
And the department doesn't have a view on the factors or the way it's laid out or the phrasing?
My recollection is that that particular provision is one with which the department agrees. And that's an important consideration, certainly, to get the increase for those firearms that go to end users that are going to do more danger to communities with that material and with those firearms.
I have a question for you on a different specific offense characteristic that came up, and that is regarding stolen firearms and the possible addition of ghost guns to that, and the rebuttable presumption on the mens rea. And I was curious about the rationale for kind of flipping the normal burden of proof on the mens rea element there.
So it's been for years, Commissioner, it's been for years the standard that stolen firearms and firearms with a without a serial number or an obliterated serial number would get an enhancement regardless of mens rea. So the department is, in many respects, urging some degree of leniency here. What we're looking for is a model that's been used by the Commission in the past. There's a number of examples in the current guidelines where rebuttable presumptions have used and work. In the mortgage fraud context under Section 2B, there is a rebuttable presumption to value the collateral that the bank gets back. based on the tax assessed value. In child sex abuse cases, there is a rebuttable presumption for the imposition of the undue influence enhancement, both in the 2A guideline and the related 2G trafficking guideline. And there is a final one in Section 8 for organizational sentencing with respect to whether or not the benefit to the corporation for corporate compliance programs applies. So we think looking at those 4 examples through the guidelines, those present a good opportunity and a good way to do it that has worked in the past, and that's why we recommend this method for the future.
One follow-up to that. Do any of those examples relate to mens rea, or are those, I can look them up, but are those all separate from mens rea issues on the rebuttable presumptions?
If I were looking at them, I would say that undue influence is pretty close to mens rea on the 2A 3.2 and 2G 1.3. Certainly for the corporate compliance, it is, because it has to do with whether or not a corporation can get a corporate compliance benefit when people in positions of leadership are involved in the wrongdoing.
Good morning. Thank you for your testimony. The department urges the commission to set the base offense level 3 or 4 levels above what the current base offense level is. And the commission, I think in our materials, have suggested or put out for comment a 2-level increase. Some commentators have noted, and I think it was in the Federal Defender's materials, that even under the existing guidelines with the current base offense levels, firearms offenders, and certainly in particular straw purchasers, receive fair variances in their sentences with some frequency. I can't remember the exact percentage. So what is, and I guess the argument then is, so the guidelines as they currently stand are adequately addressing, ultimately the conduct and the sentences. Now, certainly there's a directive by Congress, but in particular, to that argument that courts are varying or sentences are varying at a fairly not inconsequential clip, what is the justification for the 3 to 4 level increase to the base offense level?
Commissioner Boom, my recollection of the Commission's data suggests that while firearms variations have increased in recent years, there are still fewer departures and variances from firearm sentences than other sentences under the guidelines. So that would be a reason to consider an additional upward adjustment to the base or specific offense characteristics. It also comes down to specific deterrence, that is, incapacitation of an individual who has been a danger to the community. The recidivism statistics that the Commission has tallied, one can read those different ways, but the way we look at it is that taking someone out of the community and providing them a longer sentence is something that leads to less recidivism in the future. And that's really what we're trying to do, is get rid of drivers of violent crime in the communities that are most impacted by gun violence and violent crime.
There will be some who, there will be some who testify after you who will urge the commission to delay doing things right now, to study it more. What's the department's view on why that might not be the best thing to do at this point?
Judge, we're coming off of a summer of violence last summer. My tenure at ATF as acting director spanned Buffalo and Uvalde and Tulsa and Highland Park. Congress passed the BISCA in relation particularly to Uvalde. So there is some urgency to act at this point on those. This commission's also had the opportunity to be studying this in depth with its staff for the last 6 months or so. We think the time is right to do it now to address the rising problem of gun violence, particularly in many communities across America.
And to adopt the department's view at 3 to 4 level increase as opposed to some other level increase after having studied, and I'm just curious if any further study is necessary to look at all those issues.
Judge, that's something that you and the commissioners obviously need to decide. The department really would like decisions on this and the adjustments that the commission is prepared to make expeditiously in short order in order to carry out the directives of Congress.
Thank you.
Do we have the authority, in light of our proposal to raise base offense levels 1 or 2 levels, do we have the authority to raise them 4 levels as a matter of administrative law and fair notice?
That is not a question I know the answer to. The department will have to get back to you on that. I will say this. The commission has, in the past, raised offense levels beyond the directives of a congressional statute. The defender positions talk about this. They suggest it should have gone the other way. But when, in 1995, high-capacity magazine firearms were enhanced, the directive was only to enhance it for nexus to particular activity, and the commission took the step of adjusting it upward for all. So we think the commission certainly has past precedents to be able to do that. I defer to any future comments from the department on the administrative law question.
Commissioner Wroblewski, quiet today, right now. All right. Any further questions of this witness? As they say in the old, I guess it's old Baptist church back home, speak now, forever hold your peace. Thank you, U.S. Attorney Restaino. We appreciate your testimony today on behalf of the Department of Justice. Thank you.
Thank you, Judge Reeves and members of the commission.
All right. Good morning.
Good morning, Commissioners.
Our second panel provides us with the federal public defender's perspective on this issue. To present that perspective, we have with us Leslie E. Scott, who serves as an attorney with the Sentencing Resource Council for the Federal Public and Community Defenders. In that role, Ms. Scott represents defender interests before the Sentencing Commission, develops litigation strategies, and develops trainings for defense attorneys. Ms. Scott has previously taught at Detroit Mercy School of Law and served as a public defender in the Western District of New York. Ms. Scott, we're ready when you are.
Thank you, Judge, and thank you, Commissioners, for inviting me to speak on this important topic. Gun violence takes an incalculable toll on our communities and on our country. Where I grew up, on the east side of Detroit, it is an ever-present reality. Both in my community and in my legal practice, I have witnessed the devastating human costs of this epidemic firsthand. Defenders are eager to help find solutions to protect our communities, but a knee-jerk, punitive response to the directive in the Bipartisan Safer Communities Act will not make us safer. Specifically, Option 2, which would raise base offense levels blindly across 2K2.1, is destructive and counterproductive. The Commission is uniquely situated to inject empiricism, deliberation, and evidence into a reactive discourse that has for too long been driven by fear. We ask the Commission to do so and to conduct the careful review to guide a measured and to guide a targeted response. Indeed, Senators Cory Booker and Christopher Murphy, both lead sponsors of the BISCA, wrote the Commission in December to make this request. They asked the Commission to engage in a, quote, thorough process of researching, collecting, and analyzing data before implementing changes to, quote, avoid any unintended consequences that result in unfair or unjust policies. There are two primary reasons why the Commission should stay its hand. First, historical patterns prove that a reactive and a punitive response to the BISCA would entrench and expand significant and pervasive racial disparities in federal firearm enforcement. Criminal law enforcement in America is a story of gross racialized inequities, with Black, brown, and poor individuals often facing much harsher penalties than others. We saw that with the failed war on drugs, and we saw that with the racial disparities caused by the now discredited 100-to-1 crack to powder cocaine sentencing ratio. We see this pattern play out today in federal firearm prosecutions as well. In the District of Arizona, which has a large proportion of straw purchasing cases, a staggering 79% of individuals convicted under the pre-BISCA straw purchasing statutes in the past 5 fiscal years were Hispanic. And in the Eastern District of Michigan, where I live, in the fiscal years of 2017 through 2021, an astounding 85% of people sentenced under 2K2.1 with a 922G count were Black. The Commission's recent firearms report also described a significant number of 2K21 cases that originated from traffic stops or from routine street patrols, with Black individuals making up the majority of both of those groups. Defenders applaud that report and applaud the Commission for taking important steps to understand the complex interplay between firearm sentencing policies and the racially uneven enforcement of criminal laws in this country. This is the type of information that this Commission should continue to gather, build upon, and address before implementing more punitive measures that will undoubtedly have an outsized effect on communities of color. The BISCA drafters shared this concern about this outsized effect in their December letter. The significant cost would not be offset by an improvement in community safety. Lengthy and unnecessary imprisonment destabilizes families and destabilizes communities, cutting off the essential social and economic lifelines that are most likely to thwart violence. Research consistently shows that higher incarceration rates are not associated with lower violent crime rates. Indeed, years of felon in possession prosecutions with increasingly severe penalties have not curbed gun violence, and there's no reason to think that they will start working now. The second reason to delay is that another set of reactive amendments to 2K2.1 will further compromise an already flawed guideline. 2K21 has seen significant increases over the years, often in response to legislative changes and directives and requests from law enforcement and the DOJ. But sentencing data suggests that the current penalties are either too high or are high enough as the majority of judges sentence within or below the range in 2K2.1. If you feel you cannot delay, we ask you to reject across the board upward ratchets under option 2. Senators Booker and Murphy have urged the Commission to reject the government's proposal of a 4-level increase across the board. The intent is to have the most culpable players in straw purchasing targeted, not the low-level individuals who have been targeted in the past. To conclude, we cannot punish our way out of the social ills that result from decades of economic, political, and social disinvestment in communities of color. These are structural and systemic problems that require a more thoughtful and nuanced method than a back-end tough-on-crime response. We're finally starting to employ some of these evidence-based public health community intervention measures to drug crimes, and a growing consensus is calling on us to do the same for gun crime prevention. We ask the Commission to please proceed cautiously so as not to inadvertently repeat the historic policy failures from the past that have led to the marginalization, stigmatization, and the mass incarceration of communities of color. Thank you, and I'd appreciate questions.
Thank you. Ms. Scott, I turn to my fellow commissioners. Commissioner May, Vice Chair May.
Thank you, Ms. Scott, for your testimony today, and for, I know we understand pinch hitting here at the end, so we appreciate you being here today. You mentioned today, and it's mentioned in the written submission, this kind of this encouragement of careful study before we act. Do you have specific ideas on the kind of study that we maybe haven't done that should be done, or that maybe we have done, or?
Absolutely. Thank you for that question. And I think that that's an important one. First and foremost, I think it would be important for the commission to gather data about these brand new BSCA statutes, and they are relatively new. The BSCA was passed less than 1 year ago, and there was a question that was presented to my colleague this morning about whether or not there would be sort of a disproportionate impact on minority communities through these penalty enhancements, and the answer was we hope not, but we're not sure yet. And I submit that that's not good enough. This is an important topic and we need to be sure. And so I'd ask the commission to start by gathering data about who is currently being prosecuted under these two new statutes, 932 and 933. Look at these cases to determine, for instance, whether the majority of these prosecutions involve low-level straw purchasers, which is frankly what we've seen in the past with the pre-BSCA statutes, which were fairly low-level, vulnerable individuals. It's part of the reason why, as Commissioner Boone pointed out, courts are sentencing below the guidelines approximately 70% of the time in these statutes, which suggests that these are not sort of the upstream high-level cases that the BSCA is purportedly intended to target. We want to avoid some of the mistakes that we've seen with the Commission's drug quantity table, for instance, where drug quantities were set sort of as a proxy for role, but as public defenders on the ground, what we were seeing is that a lot of low-level, drug-addicted street dealers are getting charged with these high quantities, despite the fact that they are not major drug traffickers. And so we're concerned that these new prosecutions under the BSCA will sort of track those same mistakes. We want the commission to gather data on demographics. What are the demographics of the people who will be sentenced under the new BSCA statutes? Senators Booker and Murphy were concerned about demographics and wrote about it in their December letter, where they talked about the commission needing to take the time to ensure that any sort of guideline enhancement will not disproportionately affect low-income communities and communities of color. Second, the commission should review its guideline to look at unwarranted racial disparities more broadly in 2K 2.1, and the commission has done a lot of this work already, and we commend the commission and appreciate that. The 2022 firearms report for this summer looked at the frequency of certain SOC enhancements in the 2K 2.1 guideline, but it would be important to look at the race breakdown of who is receiving those enhancements. Sentencing data also can only tell us so much, and so the commission could do a special coding project to determine if there are racially disparate patterns in not just sentencing, but also in charging and in plea bargaining. Beyond race, it would be important to look at ethnicity and to look at gender. Many straw purchase cases involve women, mothers, girlfriends, wives, who are in coercive relationships, and many trafficking cases originate at the southwest border, but prosecutions historically have targeted, as I've mentioned before, these low-level, fungible purchasers. In addition, we would hope that the commission would gather information to better execute the congressional directive on straw purchasers without significant criminal histories. Congress has made it clear that it wants these individuals' sentences to reflect the defendant's role and culpability and any coercion, domestic violence survivor history, or other mitigating factors. And we don't think that this proposed amendment sufficiently does so at this time. The commission could do a special coding project to learn more about straw purchasing offenses and the circumstances of the people committing those offenses. Fourth, the commission could gather additional information to better execute the directive on gangs and cartel affiliation. The commission can use its empirical prowess to study current cases and define limiting principles We know the many pitfalls and the many inaccuracies of gang databases. The Commission can explore data-driven ways to avoid making mistakes in terms of identifying affiliated persons, mistakes that would be unjust but would also result in unwarranted disparities and lifelong consequences for the people involved. Many trafficking cases in the Southwest involve young Hispanic American individuals who are paid a small amount to purchase a firearm that may eventually make its way, into the hands of the cartel. But the individuals themselves are not affiliated with the cartel at all, and so this enhancement, it risks sort of looping these individuals in with individuals who are more culpable. I believe it was Vice Chair Restrepo who mentioned the Rahimi case, and PAG also in their letter suggested that the Commission needs to study the effects of that Fifth Circuit decision and how it might impact implementation of the BISCA. And also, as Commissioner Wong, you mentioned earlier, studying the definition of firearm and how the government's proposal related to incorporating machine guns into this definition could potentially lead to unintended consequences, such as individuals being enhanced for having 2 firearms when they really do not. So this area is just ripe for study, and we're happy to expand upon this and give other ideas.
A potential study of this.
Sure.
We should go down this road. So in response to the question about the racial disparity, your colleague suggested that firearms offenses have a disparate impact in terms of violence in communities of color. Should we study that? I mean, should we study who the victims of this firearm violence is? And if we do, what do we do with that information?
Absolutely. I think it would be important to study who the victims of firearm crimes are. I think that there's research in this area already that show that low-income minority communities disproportionately face firearm violence, and I think the important...
Hypothetically speaking, let's assume that's true.
Correct.
What do we do with that information?
I think an important thing to do would be to figure out why what we've done in the past hasn't worked for these communities. In the past, with respect to firearms, with respect to drugs, the approach that the justice system broadly, I think, has taken and sentencing as well has been to enhance penalties sort of in the name of or for the sake of enhancing public safety in these communities. But what we've seen is that has not worked. And so I think that what you do with that information is you study what these communities, the people in these communities, would like to see in terms of enhancing safety, and also look at what the research that's out there on deterrence already tells us about why enhancing penalties does not promote public safety. This idea that we can sort of punish our way out of crime in these low-income communities is born, I think, from at least 3 false presumptions. The first false presumption is that there aren't already penalties baked into the guidelines and congressional legislation, mandatory minimums, that are sufficient to incapacitate people that are perceived as dangerous. We know that there are. With respect to firearms, there are mandatory minimums that apply under 924C when a firearm is possessed in drug trafficking or for furthering crimes of violence. We know that there are enhancements baked into the base offense levels at 2K 2.1 for people that have certain prior convictions, both drug trafficking and crimes of violence. Potentially these categories will be expanded if this commission decides to abandon the categorical approach. And there's the career offender, there's ACCA, so we know that there are enough penalties in place at this point. The second false presumption is that long periods of probation or supervised release are somehow a walk in the park for our clients. And they are not. I can't tell you how many conversations I had in Buffalo with clients of mine who pondered whether it might be easier to go back to jail and get off papers than to remain free in the community and stay on papers. And that's simply because there is a significant intrusion on people's privacy interests, their travel interests, and their liberty interests not to mention the collateral consequences that come with a felony conviction, especially for somebody like a straw purchaser who does not have significant criminal history. Third, and this is really my last point to answer your question, Judge, and that is that the question presumes that we can punish our way out of gun crimes and gun violence, but the research simply doesn't support that premise. The research suggests that lengthier sentences in service of deterrence and public safety don't work, just like draconian drug war sentences did not do anything to decrease drug crimes or drug overdose death rates. We heard this morning a discussion about Project Exile, Project Safe Neighborhoods, and Operation Ceasefire. And frankly, the studies of those programs found little to no impact of harsher gun penalties on crime rates. The positive impacts were largely attributed to intervention measures that were put in place sort of at the front end. And that's really what has a positive impact: job training, social services, mental health counseling, education programs. Studies of mandatory minimums in Michigan, Florida, Massachusetts also found no deterrent effect to mandatory minimums for gun crimes. So I would suggest that we focus on front-end intervention and community prevention measures as opposed to enhanced penalties.
Commissioner Gleason has a question. Commissioner Gleason, if you can hear me, please ask your question.
I can, and thank you, Judge Reeves. Thank you, Ms. Scott.
Thank you.
You know, my question, there's no question that the racial disparity issue that's already been referenced is front and center, and given the sordid history of racial disparities when it comes to firearm punishments. But my question, it's kind of a half comment, half question. My question is, what is increasing the sentence length for these offenders accomplish, besides obviously incapacitating them for a little bit longer? But I'm interested in the correlation between recidivism rates and increased sentence lengths. And it's not clear to me that it might make some segment of the communities we care about, feel better if there are longer sentence lengths. But I think there might be some data out there that show that those increased sentence lengths do nothing but increase recidivism rates for those who serve them. So is there anything, Ms. Scott, that you can point us to or that we might do so we can have like an informed decision as to whether whatever we might choose, 4 levels or 2 levels, what that would accomplish in terms of the goals of sentencing? Because I'm not sure an incremental increase in the sentence lengths of these offenders is a value add. Let me just stop there and see if there's anything you can point us to in that regard.
Absolutely. Thank you for that question, Judge. I think, I certainly have done research in this area of recidivism and public safety and deterrence, and a lot of my scholarship focuses on these questions. We cite to some of the studies in our written testimony that we submitted in February. Certainly, I could point to Daniel Nagin at Carnegie Mellon. He's one of the sort of lead researchers in this area, and he's pointed to the fact that it's really the certainty of punishment that has a stronger deterrent effect than the severity of any sentence length. And in fact, in 2016, I believe it was, the DOJ published a short report called the five things about deterrence, or 5 things you need to know about deterrence. And the DOJ itself cited Daniel Nagin's research for the authority that really it's the certainty of punishment over and above any sort of enhancement in sentence length that serves a deterrent purpose. And I think that DOJ report also talked about some of the significant costs that are associated with increasing sentencing lengths. and concluded that any sort of slight or minimal deterrence impact was significantly outweighed by those costs. In the gun context in particular, and I'm happy to provide the Commission with these studies, there was a report by Michael Townroy, I believe his name is, also a scholar and professor, who makes the same arguments that lengthening punishment does little to no good in terms of decreasing rates of gun crime. The other suggested reading piece that I have is Emily Bazelon. Her book, Charged, Chapter 4, talks about gun courts. She does interviews with young men, predominantly black men, I believe in the inner city Chicago area, who talk about this perceived need to carry a gun to feel safe because of the danger in lower income inner city communities, black and brown communities, the danger of living there, danger that's sort of a result of our policies and our disinvestment in these communities. So there are a number of reading materials that we're happy to provide. My own research has found that all of this makes sense, and it makes sense for a couple of reasons. One, actors who commit crimes often are not consciously and rationally weighing the costs and benefits of their actions. They're not thinking about, will I get caught? I think most presume they will not, or they would not engage in the conduct. And so they're just not weighing those risks and benefits. They're not thinking, if I get caught, will I be sentenced in federal court and subject to harsher federal guidelines? The fact of the matter, most people are prosecuted in state court. And so they're not thinking about that. They're not aware of the penalties in federal court. They're not aware of the federal sentencing guidelines. And so really it's this sort of rational calculation that I think is the foundation for this belief that enhancing penalties will somehow deter. It's just not there. Instead, it's really the certainty of punishment and also increasing legitimacy in the eyes of these communities. If these communities feel as though policing and law enforcement is legitimate and prosecutorial initiatives are legitimate, they will respect the law. And that requires eradicating some of these race-based differences.
Thank you, Vice Chair Murray, and then Commissioner Boone, I believe.
Thank you so much for being here, Ms. Gunn, and especially thank you for jumping in at the last minute. We really appreciate it. And
thank you.
Having someone else's written testimony, that's a hard thing to do. I had a question about the kind of list of research projects that you gave in response to Commissioner Vice Chair Mate's comment, which was helpful. It struck me that the one of those that is the most new is studying the kind of implementation of the BISCA. How will enforcement go? Because that's something we haven't been able to study before because there was no BISCA.
Correct.
But I wonder if you could play out a little bit how the kind of results of that sort of study would help us and would kind of operationalize. I mean, it strikes me that we are in a context where Congress gave us a directive, a part of that directive, and we can delay it for a year without violating the technical terms of the directive, but like if, we have this directive that says we have to increase penalties on straw purchasers, right? And so 932 and 933 are part of that. And what we've proposed is a 1 or 2 level increase, which is kind of the lowest you could do as an increase. So say we were to get the results of this kind of study and it says, yeah, these are all really low-level people. They don't, you should not, and the natural inference is you should not be increasing levels very much. How would that leave us in a place different than where we are right now, which is we have to increase them by directive of Congress, and we've proposed the smallest possible increase?
Yes, and that's a good question. I think that one thing that the Commission could do, and one thing that the Commission has done in the past, is inform Congress about the results of the studies that it has done. And not just inform Congress, but the Commission has made recommendations to Congress based on its findings. With respect to the career offender guideline, the Commission has made recommendations to Congress with respect to 924C and the way that has been implemented. And so we appreciate this very important role that the Commission plays in sort of filling in some of the gaps, frankly, for Congress. I think the Commission was set up to do just that. You have the skilled staff, you have the expertise, you have the empirical prowess to report back to Congress to let Congress know that you've asked us to implement this directive. We understand that we have to do that, but what you intended when you asked us to implement this directive was to target a certain group of individuals. You intended to target the more culpable, high level, I've heard people refer to them as upstream, people who are perceived to be facilitating the gun violence that occurred tragically over the summer. And here's why we believe that this directive misses the mark. Here's why we believe that if we implement the directive in the way that it's written, we will not be furthering congressional intent. I think that you could do that, and you could wait for a response from Congress to see how to move forward. Certainly, I think that Senators Booker and Murphy in their letter suggested that the commission has to take a pause and think about these issues, study these issues, research them before taking further actions because of the racial disparities that we've been talking about today.
All right. Thank you for your testimony.
Thank you.
For stepping in last minute. That's a difficult thing to do. The federal defenders have urged the commission either to wait and study these issues, but if we're going to select one of the options, to narrow any increase in the base offense level to only straw purchasers and traffickers, pursuant to the sort of the most narrow reading of the Congress's, I guess, directive. But as the Department of Justice points out, at the same time, Congress increased the statutory maximum for prohibited persons when they enacted the statute. And so, the argument is, isn't that an indication that Congress also intended that the base offense levels for prohibited persons under 922G also increase? And so my question is, to address that and then address the, the parity issue. Why would a trafficker, as you note, oftentimes it can be a girlfriend, it can be a grandmother, it can be a relative. Why should that base offense level be higher than the actual prohibited person? So that's one question that I had. And then the other is, you certainly give us a lot of great ideas on additional data gathering. One of the more recent studies, a series of studies that the Commission recently put out, was the recidivism studies. And the recidivism studies show that firearms offenders recidivate at the highest rate, approaching 70%. And so in light of that, the Department of Justice argued in the previous panel that increasing the offense level would protect the public and at least provide a deterrent for folks who are proven to recidivate at these really high levels. So I guess, I'm sorry, I just kept thinking of, additional questions as I was sitting here. So I have two, and that's the two, if we have time.
You do.
Okay.
And feel free. I know I can be long-winded, so feel free to cut me off if I'm going over my time. But I appreciate both of those questions. I think they are important questions, so I'll address them in order. First is the proportionality question and sort of this perceived lack of parity between prohibited persons and straw purchasers. I have 4 points that I think I want to make in response to that question. First is just to sort of remind everybody that the Commission's overarching obligation is to establish sentencing policies that are proportional to the severity of the conduct. In other words, we've all heard the saying, the punishment should fit the crime, and should fit the crime that this individual committed, not some arbitrary statutory norm created for a crime that somebody else committed. And so the Enabling Act sets forth one primary purpose of the Commission, which is to establish sentencing policies that reflect the purposes of 3553A, and in turn, 3553A requires courts to impose a sentence that is sufficient but not greater than necessary. And so it's important not to lose sight of that proportionality question. And so how does the commission know whether the sentences that are anchored to its guidelines are sufficient? Of course, the commission knows by looking at the data, by this sort of continual feedback loop between the commission and the courts. And the data for 2K 2.1 show that courts are either sentencing within or below the guidelines, including for felon in possession crimes. There are only, I believe the figure is 5% of sentences under 2K 2.1 that are above the guideline range. And so that tells us that there is no need to increase base offense levels across the board, even for proportionality's sake. Second, for straw purchasers with mitigating circumstances who could be viewed as the least culpable, Commissioner Boom, you mentioned grandparents and mothers. It is our hope that, and frankly, it's our hope and it's also the BISCA's stated intention, that increases in punishment will be offset by the mitigating role reduction. The Deputy Attorney General in her October letter expressed this concern that sentencing ranges for straw purchasers would be higher than the ranges for people they are purchasing for, but the reality on the ground, we believe, is that just isn't going to be the case. And that's because straw purchasers are in criminal history category 1, whereas felon in possession, typically they are in higher criminal history categories. And also because the guideline at 2K 2.1 compounds criminal history in so many different ways with its base offense level enhancements, we believe that it'll be a rare case where a straw purchaser will actually face a higher guideline range than a prohibited person. Even if you don't increase across the board, which we're arguing against. For those straw purchasers where there is sort of an outlier, outsized guideline, we know that sentencing courts are sentencing below the guidelines in these cases and will likely continue to do so. Our third point is that you simply don't fix something that's broken by breaking it more. The straw purchasing guidelines have been inflated over the years. In some instances, it's our belief that those have not been empirically based increases, and so it's counterproductive, counterintuitive, and unsound policy to anchor the prohibited person guideline to an arbitrarily inflated straw purchasing guideline. The last point I'll make before I move to your second question is relates to the intention of the BISCA and the letter that you all received in December from Senators Murphy and Booker. It was the intent of the BISCA to hold accountable those most culpable in the firearms trafficking chain. And as I've already said, it remains to be seen whether the new BISCA statutes will be used in this way, or if the bulk of prosecutions will continue to be what we see now, low-level people being prosecuted for straw purchasing. Senators Booker and Murphy urged you to review the data, to devise evidence-based policies, to execute this directive, and this is the type of inquiry we would like to see the commission make. My answer for the second question is much shorter, and it's that we hear your concerns related to recidivism and the recidivism reports that the commission has come out with. I think it's a complex topic. It's a nuanced topic. I can't do it justice in this short time, so I'll just make a couple of observations about the two reports that you're referring to. The Commission's firearms research on recidivism has been inconclusive as to the impact of sentence length on recidivism. And so while there are suggestions that firearms offenders recidivate at a higher level, what we're really concerned with is, what does this mean? What is the impact of length on the likelihood of recidivism down the line? And so for firearms offenses generally, the 2021 firearms recidivism report found, quote, that the data did not show a clear relationship between sentence length and recidivism. And the 2019 report found, quote, that the association between sentence length and rate of recidivism among both firearms and non-firearms offenders was less clear. And when you look, and I won't get into it, but when you look more closely at the data, there is even a suggestion that as you sort of increase in sentence length for firearms offenders, that recidivism increases as well. And that's something the commission should be thinking a lot about, because it suggests that the deterrence research is correct, that lengthening imprisonment is not a sound sort of basis to cut off the risk of recidivism and rearrest.
What about public protection?
Public protection should be sort of at the forefront of the Commission's mind, and I guess the point that I've been trying to make is that it does not serve the public, it does not protect the public to enhance sentences. There have been shown criminogenic effects of prison. And I think we need to be thinking beyond sort of the short-term public protection. You can incapacitate somebody for a few years, maybe even 5 years, but eventually they will be released back into their communities. And so we should be thinking about long-term public protection. And when we're releasing individuals back into their communities after ripping them from their families, from educational opportunities, from their work, we're sort of destabilizing these individuals and their families, and potentially leading to greater public safety risks down the line. This commission is considering ATI initiatives as part of this amendment cycle. And so I'd urge you to think about sort of the ATI measures that you're considering and how those are sort of in tension with this amendment and in tension with the idea that we can incarcerate our way out of the crime problem.
Thank you.
Commissioner Wroblewski.
Thank you, Mr. Chairman, and thank you so much, Ms. Scott.
Thank you.
Can I just follow up on that? What if the commission decided to focus any increased penalties just on those repeat offenders, people who had prior crimes of violence in their record, and so to try to avoid the people who you're talking about who are in the midst of an educational experience and ripping them out of the educational experience, which you talked about, and just focus strictly on that. And that's where the commission's research, the empirical studies, not about deterrence, but about incapacitation, that those people are the ones who really are the dangerous ones. And if we focused there, would you still have the same concerns? And then I have a quick question about another, slightly off topic.
Yes, thank you for that question. I guess I'm still struggling to see how the commission would focus there. And again, this goes back, I guess, to our point of the need for further study and discourse on the topic, because straw purchasers who are sort of targeted in the BISCA, by virtue of being a straw purchaser, they do not have a significant criminal history.
Yeah, what I meant was the felon in possession cases that have prior crimes of violence. I agree with you on the straw purchasers. We're not going to see those.
Right. So I guess my answer to that would be that the guideline already focuses its sort of the most punitive measures on the individuals that you were talking about. So the structure, as you know, of 2K2.1 is that the subpart A provisions have enhancements baked in for people with certain types of prior convictions that are deemed to be more dangerous than others. So you have the people with certain crimes of violence and drug trafficking priors will receive higher base offense levels. People who possess a large capacity magazine are at heightened base offense levels by virtue of that. There's a 4-level enhancement for people who commit the instant offense in connection with another felony. There's up to, I believe, a 10-level enhancement for people who traffic in extremely large numbers of firearms. There's the enhancement for obliterated serial numbers and stolen weapons. And so I guess my response to your question would be that defenders feel that those concerns, those valid concerns that you raised, they are already baked into this guideline in numerous ways, and not to mention the ACCA career offender, 924C, all which carry a significant, sometimes mandatory imprisonment. So we just don't see a need to do anything more than what has already been done. And certainly the courts do not see a need to do anything more based on the sentencing data that courts are going below the guidelines in these cases. And you've had several judges that have actually been fairly outspoken about the problems with the firearms guideline. I think of Chief Judge Battalion in Nebraska, who has talked about the problems with the guideline, that some of these decisions to enhance penalties have not been empirically based and have instead been pursuant to directives. And so you have some judges that are refusing to follow the guideline for that reason. And so I risk that doing what you're asking or suggesting the commission might do, judges will just continue not to follow the guideline.
Thank you, Ms. Scott.
Thank you, Ms. Scott. It's time for us. You've done well.
Thank
it's
you,
time
Judge.
for us to move on to our next panel. We appreciate your testimony.
I appreciate being invited today. Thank you.
Our third group of panelists will provide us with the perspectives on this issue from two of our advisory groups. First, we will hear from Marlo Kadedu, who serves as the Fifth Circuit representative to the Sentencing Commission's Practitioners Advisory Group. Ms. Kadedu is a solo criminal defense practitioner who handles federal cases across the nation. Ms. Kadedu has previously served as a steering committee member on the American Bar Association's Death Penalty Representation Project. Second, we will hear from Joshua Luria, who serves as vice chair of the Sentencing Commission's Probation Officers Advisory Group. Mr. Luria serves as a supervisory U.S. probation officer in the Middle District of Florida. He has previously served as a U.S. probation officer in Brooklyn, New York. Ms. Kadedu, we're ready whenever you are.
Thank you, Judge Reeves. And members of the Sentencing Commission, I appreciate the opportunity on behalf of the Practitioners Advisory Group to address you. As you know, Practitioners Advisory Group is composed of attorneys in private practice who engage in criminal defense practice. My testimony today obviously will cover firearms. Many of the Commission's proposed changes to Section 2K2.1 are in response to the passage of the Bipartisan Safer Communities Act, which requires the Commission to both review and amend its guidelines. The PAG recommends against any amendment of 2K2.1 at this time and instead recommends that review and study be conducted before any amendment. While the BISCA directs the Commission to amend its guidelines, it does not contain any timetable for that and directs the Commission to review and amend prior to amending. Amending without review would be in fact contrary to Congress's directive. There are several reasons why careful review is warranted here. And first, as other commentators have noted, there are disproportionate racial disparities in charging under the current firearms statutes. The PAG recommends that any amendment to 2K2.1 be structured to ameliorate rather than exacerbate racial disparities. Second, historically, courts have imposed below guideline sentences at a significant rate when sentencing straw purchasers and other offenders under 2K2.1. The Commission statistics show that a significant number of sentences imposed pursuant to 2K2.1 were below the guidelines, but the Commission is now considering increasing the recommended sentencing ranges under 2K2.1 for many defendants. Implementing substantial increases without first understanding and accounting for the reasons for those increases, or for the reasons behind the historical prevalence of below guideline sentences, either ensures an even higher rate of below guidelines.
Has your microphone gone off?
My microphone has gone off.
Yeah. So just speak louder because I think it is off.
Yes.
I don't see a green light.
It's blinking red.
It's blinking red.
All right, I'll do my best. I'll use my courtroom voice. Implementing substantial increases without first understanding and accounting for the reasons for those increases either ensures an even higher rate of below guideline sentences in the future or guarantees that less culpable individuals will be incarcerated for longer periods of time. Review and study would yield an understanding of why courts so frequently elect to depart downward and could suggest more appropriate modifications to the guidelines. Third, many sentences under 2K2.1 arise from prosecutions under Section 922, 18 U.S.C. Section 922. One provision of this statute, G8, criminalizes possession of a firearm by persons subject to domestic violence protective orders. As the court is aware, recently the Fifth Circuit held this portion of 922 unconstitutional in Rahimi. The rationale of the Rahimi court potentially calls into question the constitutionality of several other portions of that statute. The applicability of the current version of 2K2.1 and the proposed amended version depends in some respects on a defendant being found to be a prohibited person. Likewise, some of the new offenses created by the BISCA and accounted for in the proposed amendments depend on the transfer of firearms to prohibited persons who are prohibited due to domestic violence protective orders. If the Rahimi decision withstands further challenge, then of course it seems prudent that revisions or amendments to 2K2.1 should await further study and review of the impact of that case. There are other aspects of 2K2.1 that merit review and study prior to amendment. These include changing the standard of proof from knowingly to the ambiguous having reason to believe, and I would point out that the PAG certainly would oppose the department's proposal for a rebuttable presumption mens rea that is stands for obliterated or stolen guns or ghost guns. I believe that the Department of Justice has advocated for a rebuttable presumption. The PAG would definitely oppose that. That is contrary to the way the guidelines operate. It's contrary to our system of justice. The department has the burden of proof at all times at sentencing. In the alternative, if the Commission does decide to amend 2K2.1 without further study, the PAG recommends option 1 because that is the more narrowly drawn. The PAG recommends, thank you. The PAG does, however, recommend an important change to option 1 because in the PAG's view, the current version of 2K2.1 B9 and option 1 is inconsistent with the BISCA in several respects. First, the BISCA requires that mitigating factors be considered for defendants who are straw purchasers without significant criminal histories. However, option 1 places a number of additional limitations on the consideration of mitigating factors beyond those in the BISCA. Second, the BISCA does not define without significant criminal histories, but option 1 is written to apply only to a defendant who does not have more than one criminal history point. The PAG believes that it should be left to the court to determine what without significant criminal histories means. Third, the BISCA requires that any guideline amendment in this area should reflect the defendant's role and culpability in any coercion, domestic violence, survivor history, or other mitigating factors. But the language of option 1 is more restrictive than the language in BISCA. Option 1 contemplates only consideration of a defendant motivated by an intimate or familial relationship or by threats or fear. Moreover, nowhere in option 1 is the sentencing court directed to consider the all-important catch-all of other mitigating factors that BISCA suggests. Finally, the BISCA does not quantify the extent of a reduction that a defendant should receive, yet the amendment proposes a 1-point reduction. In order, therefore, for option 1 to be consistent with the directives of BISCA, the PAG recommends that 2K2.1B9 be redrafted as follows. A downward departure may be warranted for any defendant convicted under the requisite list of statutes if that defendant is without significant criminal history. The extent of the downward departure may be based upon consideration of the defendant's role and culpability, any coercion, the defendant's domestic violence survivor history, or other mitigating factors. Without these changes to 2K2.1B9, straw purchasers with these and other mitigating factors risk being sentenced to longer sentences than the prohibited persons for whom they are purchasing. And that concept runs contrary to the intent of BISCA and also common sense. Thank you.
Thank you, Ms. Cadedo. Mr. Loria.
morning. On behalf of the Probation Officer Advisory Group, thank you for the opportunity to provide testimony regarding the proposed amendment to Section 2K 2.1. According to a recent study on federal firearms offenses conducted by the Commission and published in July of 2022, Section 2K 2.1 has a higher than average fidelity to within guideline range sentences, with 49.6% in range sentences compared to the 39.9% for all other offenders. Section 2K 2.1 has a strong anchoring effect on sentencing, and POAG recognizes that is, at least in part, due to how seriously the federal system takes firearms offenses, as it should, considering the study further pointed out that defendants sentenced under Section 2K 2.1 have the highest average number of prior convictions at 9.4, and that 53.1% of the defendants under Section 2K 2.1 had a criminal history category of 4, 5, or 6. Additionally, 60.6% of the firearms offenders in 2021 had at least one crime of violence conviction, as compared to 29% of all other offenders. POAG observed that this guideline has been well adhered to while handling offenders with the longest and most serious criminal histories. Straw purchasers account for just under 5% of all Section 2K 2.1 defendants in 2021. This will likely change as a result of the bipartisan Safer Communities Act, but POAG believes that many of the changes proposed will continue to keep high fidelity to the outcomes produced by 2K 2.1. POAG is in favor of option number 1 and relies heavily on our written testimony. The proposed amendment on this issue has many options within options. While we have written in favor of some options and stayed silent on others, I'm happy to answer any questions about any of the options, though I'm going to focus my initial statement on some of the areas that we think are the most important parts of our position. POAG proposes that subsection B5A and B5B be combined into a single paragraph. We observe that the two issues are similar enough to be contained as a part of a single paragraph of analysis, and we recommend that the paragraph's enhancement be 2 levels. The B5C section would then become B5B, and POAG would suggest that this conduct result in a 5-level increase. POAG has several recommendations related to the proposed amendment to create a subsection B8, the first of which is to make this subsection offense-based. The rationale behind this was to try to include those who are also receiving firearms from straw purchasers. POAG also supports the use of the reference to subsection B5 as part of subsections B8A and B9A, mainly because this will include false statement cases and make subsection B8 and B9 easier to navigate. POAG also recommends that language in subsection B8B be adjusted from participated to something more akin to affiliated with. POAG's thinking is that showing someone to be a participant may be harder than showing they were affiliated. POAG also recommends the removal of the language of 5 or more persons from B8B. POAG viewed this language as reductive in terms of the applicability. Oftentimes, a straw purchaser may be only working directly with a single point of contact for a cartel or a gang. Further, as it pertains to B8, POAG recommends that the proposed subsection B8C be deleted in its entirety. The mens rea component in this section would be extremely difficult to meet. As to subsection B9C, POAG also believes that ands rather than ors should be used, and that the section that deals with minimal knowledge should be amended to, I quote, had no reason to believe that the firearm would be used or possessed in connection with further criminal activity, end quote. POAG favors this different standard because of how devastating the outcomes can be when a criminal is able to circumvent the protections to obtain a firearm. As for ghost guns enhancements, POAG is in favor of the changes that are proposed to create this enhancement. However, POAG recommends the inclusion of a firearm manufactured prior to the Gun Control Act of 1968 as part of the other than provision in the main body of the guidelines and the respective commentary sections. The Commission has also asked about further revisions to Section 2K 2.1. POAG does not recommend the creation of special enhancements for burglary of a federal firearms license holder. POAG observed that a defendant engaged in that conduct will likely face an appropriate enhancement that's captured under a variety of other sections. POAG also favors the Commission's implementing some method for accounting for prior federal or state convictions for felon in possession of firearm and ammunition offenses, perhaps through the base offense level, similar to a prior conviction for a crime of violence or a controlled substance offense. Again, thank you for the opportunity to share POAG's perspective. I stand ready to answer any questions.
Thank you. Commissioner Wong?
Thank you. Questions for Mr. Luria.
Yes.
If you've read the department's comments here, there seems to be just a disagreement on complexity, on hypothesizing which of the two options is more complex in application. And I was just wondering, the department says that because of the complicated structure, that option 1 would exacerbate challenges in applying 2K 2.1. And I know POAG, an overwhelming majority, favored option 1 because of ease of application. So I was hoping you could just flesh that out and explain POAG's view that about the respective merits in terms of complexity.
Certainly, and in our discussions regarding it, many of the members looked at that section B5 and thought it was really good to have all that in one area where you're going through an analysis there that's all located in one spot. Versus when you put that into the base offense level structuring, it's kind of like you're integrating that into a variety of other considerations. And that stratification ends up being a bit more versus when you're trying to really focus in on this specific issue as it pertains to straw purchasers. All of that is in one location. It's all in an SOC.
Is it CADEDU?
It is, yes.
So the question I have for you is, everybody's concerned about racial disparities, and you referenced we should make an effort to ameliorate rather than exacerbate these racial disparities. What specifically should we study to try to get there?
Well, in terms of racial disparities, obviously there are a lot of intersecting factors, but one area that we think ought to be studied and that may, in part at least, address that question is the rate of departures and variances from the guidelines and why those departures and variances occur in these particular cases. It's not clear, I think, at this juncture whether those variances and departures occur in a way that is not that themselves exacerbate racial disparities. In other words, people of color are receiving higher sentences, and people who are, and other folks are receiving below guideline sentences or variances based on factors that perhaps are not clearly race-based, but are sort of factors that end up creating that disparity itself.
So if I understand you correctly, we should study the race of the defendant and whether they were given a variance or departure on a firearms offense?
Well, we certainly think that certain we are concerned that variances and departures may be occurring in a way that is racially disparate. And so studying departures and variances, as well as some of the other factors that were suggested by the testimony of the defenders, we believe will assist in determining why those race-based disparities occur.
Thanks.
Commissioner Rubluski.
Thank you, and thank you both for being here and for testifying. I have one particular question that I want to ask you, Mr. Dano, about the mitigating factors. You and others have suggested that if any one of the mitigating factors is present, that there should be a reduction, so the net effect is no increase. And first of all, am I getting that correct?
Well, I'm not sure. So the net effect.
The net effect. So if the commission raises the penalties by 1 or 2 levels for straw purchasers in conformity with the directive, but then also provides for a mitigating adjustment of 1 or 2 levels, also pursuant to the directive, the net effect would be no increase from current penalty level.
Well, certainly for those defendants who qualify under those mitigating factors, I think as the defender's testimony points out, the purpose of BISCA was to address straw purchasers who are sort of in this, who are more culpable than than say the mom buying a gun for her son to used for target shooting, that sort of thing, and then that gets used in a way that the mom didn't anticipate. So it's our view that those mitigating factors ought to be. Essentially, if we follow the department's view and make them conjunctive, such that you have to qualify under every one, then the application will be almost nil of the mitigating factors.
Well, let me ask you
Sure.
a specific
Yes.
hypothetical.
Okay.
Let's say your best friend comes to you and says, "Can you go and buy me a gun? I'm going to use the gun to rob a bank." Okay, so if there's and I'm not going to pay you anything, so there's no financial remuneration. Presumably, it's an intimate relationship. Do you think that? But he also says, "I'm going to use the gun to rob a bank," and then does go and use the gun to rob a bank. Do you think that person should be getting the mitigating adjustment? Because I think under your framework, which is because it's an intimate relationship, because there's no money changing hands, this person would get the mitigating adjustment.
I'm not certain that the well, I'd say a few things. I think would be an unusual circumstance, I think, where a straw purchaser would be specifically told that the gun is going to be used for a particular offense. So I'm not sure how often that particular scenario will occur. I also am not certain that under those circumstances the mitigating adjustment, in fact, I think I'm going to ask on the fly. I think it's a little difficult to answer that. I need to go back and speak with the other PAG members and perhaps answer your. I think we have a couple of other of your hypotheticals that we're addressing in our written statement. So I think I'll go ahead and address that. I don't want to speak off the cuff because my sense is that the mitigating adjustment wouldn't apply under those circumstances, but I want to ensure that I'm correct in that and not speak out of turn.
Can I ask another question along the same lines? But and if you need to address it in the written statement, that's fine. Are you familiar with the criminal history proposal that the Commission has published that would provide a sentence or a guideline range, a guideline level reduction for people who have 0 criminal history points?
Yes, I am. I have read that, although that is not. I'm not.
Right. So the thing I want to ask you is, as a defense lawyer, there's a provision in there. There's an exclusion that says if you possess a weapon in connection with the offense, you don't get the 1 level reduction. And I'm curious, if you have a straw purchaser who walks into a gun store and fills out an ATF form, that's the crime, lying on the ATF form. Do you agree that that person has committed, and then of course, after the crime is completed, they've presented the form, they then get a gun. So they don't actually hold the gun until after they've presented the form, of course, because then they've purchased the weapon. In that scenario, do you think that person would be eligible for the reduction? And if so, and the reason I'm concerned about this is because the interplay between these 2 amendments, Congress said raise the penalties, and if we raise the penalties here but then reduce them over there, the net effect again is no increase in penalties and non-compliance with the directive. Do you follow the question that I'm asking?
I'm not sure. I think what I'll have to do is review it and respond in our written testimony. I will say that I think generally speaking, the penalties. I'm not as concerned about reductions in penalties as I am about increases, because our guidelines seem to be a one-way ratchet upward, and I think the department's proposal here with increasing base offense levels and with implementing the rebuttable presumption, all of those provisions, I think, will have a much greater increase in sentencing guideline ranges than some of these interplays of sections that you're discussing. But we'll address both of those hypotheticals in our written statements.
Question. First of all, thanks to both of you for being here and for your testimony. Our advisory groups are so wonderful and so helpful to us. Mr. Lurie, I have a question for you about your comment on application note 8 of the ghost guns. Could you say a little bit more about why POAG thinks we should add the reference to Gun Control Act of 1968? I know.
Certainly. That act actually, prior to that, manufacturers were not obligated to put serial numbers onto firearms. So that the point that that act gets put in there, now everybody who's manufacturing for distribution in a kind of stream of the market kind of concept, they are having to put serial numbers on. So prior to that act, you might find guns that are maybe ghost guns, but they weren't really intended to be. They were just not serial numbered because that was not the obligation at the time.
Commissioner Gleason has a question. Commissioner Gleason, if you can hear me, go ahead and ask your question.
I can. Thank you, Judge Reeves. Yeah, I have a concern, and I wonder whether it's overblown, and it relates to tinkering with the mens rea. There are at least two different ways in which it's been suggested that we could. And my concern arises out of any allocation, any sense in which we allocate the burden on the defendant produces the following kind of real world in the well of the courtroom concern. And that is, I don't know how you prove the negative except make a statement. The defendant, articulates why he or she had no reason to believe or tries to rebut a rebuttable presumption. And I don't know how you do that except make a statement. The fact findings associated with that are kind of notoriously difficult to make. I mean, it's not a science determining whether those are truthful. And here's my concern. An adverse credibility determination then, I think, has the capacity to result in an obstruction enhancement, a deprivation of 3 levels of acceptance. So between the adjustment, the adjustment for not being able to prove the absence of a mens rea, the other 5 levels, I just wonder whether this, in its implementation, would produce dramatic swings in sentence ranges that tinkering with the mens rea really doesn't contemplate and doesn't really have in mind. I'd be curious to, first of all, thanks to our 2 panelists for being present and for your input. But I'd be curious for your comment on whether that might be an unintended result from tinkering with the mens rea burden.
You may proceed.
Thank you, Judge Gleason. That's a great question, and it's a concern that the PAG shares. We are on the ground every day in courtrooms dealing with these questions, and we have to often make decisions about how to proceed, sometimes decisions to concede points that we believe that we can prove because we are afraid of enhancements or of losing acceptance of responsibility, or now potentially losing the 3rd point of acceptance of responsibility for making objections. So we're always making these strategic decisions, and I would agree that this particular strategic decision about whether, in fact, to make an effort to rebut this rebuttable presumption, if there were one, would put us again in a bind that would be extremely difficult to manage. I can see situations. I can imagine clearly situations where a defendant might be able to present evidence to rebut this presumption, but would elect not to do so for fear of exactly the collateral consequences that you mention. And so, aside from the fact that a rebuttable presumption just goes in the face of the way our criminal justice system works and the fact that the government always bears the burden of proof, I think that these additional negative consequences certainly should be considered by the Commission.
Mr. Luria, do you wish to respond?
This kind of, the inquiry kind of, I want to speak to the issue under the B8C issue. So, POAG has kind of recommended that this language be taken out in entirety. I've had cases that I've dealt with where straw purchasers were buying guns for cartel members, and I wouldn't be able to make this mens rea work because they're paid handsomely. They have no real affiliation. They don't want to be members of the group. They don't want to be, they don't want to have that maintenance of their position. There is no position to maintain. And so, I think that mens rea component under BHC really doesn't necessarily connect too well with that the group that's doing this kind of thing in furtherance of those criminal enterprises. That's just our observation that mens rea aspects tend to be really hard to apply, but I do think that they get well balanced out through departure considerations, through variance considerations by judges. They do balance that well in those instances where that's a factor that needs to be balanced. So.
Thank you. That concludes.
Thank you.
Oh, I'm sorry, Commissioner Gleason. That concludes our testimony for this part of the morning. We'll take a brief break. Please, let's agree to start back up about 11:05. And please make sure you're in your seats at that point, and we'll begin with the next round of testimony. Thank you, Mr. Luria, and thank you, Ms. Cadedo, for your testimony.
Thank you.
I'm going to remind the commissioners when you're speaking to please try to talk as loud as I talk. Because we want to, I realize we're in a real small room and we can basically hear each other, we think. But please make sure we're making sure that everyone hears the conversation. Our fourth panel will provide us with a perspective on this issue from academics and advocates. Here to provide that perspective is Rob Wilcox, who is testifying on behalf of the Zimroth Center NYU Law Working Group, which consists of researchers, policymakers, and advocates who focus on gun violence prevention, federal sentencing reform, and the prosecution of federal firearms offenses. The mission of the Zimroth Center is to promote good government practices in criminal matters with a special focus on the exercise of prosecutorial power and discretion. Mr. Wilcox is an expert on gun safety who currently serves as Senior Legal Director at Everytown for Gun Safety. Mr. Wilcox has previously worked as a private practitioner and at the Brady Center to Prevent Gun Violence. Mr. Wilcox, we're ready when you are, sir. We're getting a red signal, but speak, let's see if it's working.
All right. Thank you, Judge Reeves. I appreciate this invitation to appear before the commission. I don't know that the mic is working.
You can have mine. I'm not talking. You can have mine. It's more important that we hear you. Oh, you got it.
We're good. So, as you said, an expert in gun safety, not in microphone technology. I do want to mention our group members at the Zimroth Center NYU Law because it really is a distinguished group that I get to present on behalf of. It includes former United States attorneys, Brady United, Everytown for Gun Safety, Giffords, Community Justice Action Fund, and academics at Johns Hopkins and Loyola University of Chicago. As the chair said, I'm the senior director at Everytown and draw on about 20 years of experience in the policy and litigation space. Proud son of Brooklyn, who had a family member be shot and killed from gun violence, and have honestly met way too many survivors than I care to count who were victims of this public health and public safety crisis. I've been a key advisor on gun violence prevention legislation and executive action, and was incredibly deeply involved in the negotiation and passage of the Bipartisan Safer Communities Act. And I do think that the Act's overall context and substance is incredibly useful as you undertake your work, because this Act created several new tools and programs across multiple policy areas to take a novel approach to address the complexity of gun violence. For instance, the Act targets unlicensed sellers and creates enhanced background checks for individuals under 21. The Act invests hundreds of millions of dollars in implementing state extreme risk laws and community violence intervention programs. And the two new federal offenses, the subject of today's hearing, that prohibit straw purchasing and gun trafficking, shift federal enforcement upstream up the illegal gun pipeline. Congress's approach last session matched this administration's efforts to establish gun trafficking strike forces and their efforts to crack down on rogue gun dealers while also increasing investment in community violence intervention programs. Data show why this upstream approach is so important. A 2000 report from ATF showed that crime guns come from a highly concentrated set of gun dealers. An Everytown study showed that 75% of likely trafficked crime guns that cross state lines came from states without background check laws. And an ATF trafficking report released just last month, the first major report in 20 years, showed that guns are moving from dealers to crime at alarming speed. From 2017 to 2021, 46% of crime guns were recovered less than 3 years after purchase, a significant sign of gun trafficking. And this Act now finally addresses the straw purchasers, gun traffickers, and rogue gun dealers that all feed this diversion of illegal guns but have rarely been subject to federal prosecution. The straw purchasing and gun trafficking provisions, as well as the addition of subsection 10 and 11 to section 922D, provide enforcement mechanisms that go up and down each link of the gun trafficking chain. The law applies to any seller, including federal firearms licensees. It's important because licensed gun dealers hold a position of public trust. They're on the front line to keep firearms from being diverted into the legal market. But some gun dealers do have a strong connection to crime guns. ATF data showed that 10% of one Georgia gun dealer's average monthly sales were traced crime guns. 10% of the average monthly sales were traced crime guns. So Congress didn't just create this new tool to target significant gun trafficking operations, but also to reflect the complexity of the different links in that chain. The licensed gun dealer who's willfully blind, the girlfriend coerced into acquiring firearms as a straw buyer, the person directing the buys, the person securing the funding, the person finding the buyers, and the guy who's delivering straw purchases up the iron pipeline. The sentencing directive itself is a balanced approach reflecting this complexity. And we believe option one best reflects Congress's intent to bake the complexities into the guidelines because it requires specific findings by the sentencing judge. We recommend that option one be further refined to take into account the different mens rea of the person being sentenced, that we treat knowing and reasonable cause to believe different and give each different weight. We think that approach reflects the congressional directive for the commission to take into account, as they say, role and culpability. The commission should also make clear how federal firearms licensees fit into the guidelines and how a violation of that public trust should be handled. I do want to spend my last moment just talking about the mitigation language, which I believe is novel and deliberate. It shows Congress's intent for the commission to strike the right balance and make sure people lacking culpability are not caught up in sentencing increases for those the law wants to target. Most importantly, and potentially different from some of the prior witnesses, the reduction should apply broadly because the key sentence in the directive has two co-equal instructions based on the use of the word reflect in that sentence. First, the commission is to reflect deterrence. Second is to reflect fairness. The reduction should not require all the mitigating factors to be met in order for the departure to apply, because Congress is clearly using or language in the directive and provides a list of circumstances that don't necessarily all have to be met in order to apply. And finally, if you look at the very end of the sentence, other mitigating factors, Congress clearly is leaving it to the commission to capture additional unenumerated factors that are equally important when considering culpability. Congress's approach to address gun trafficking established new crimes to address the severity and danger of gun trafficking. And make no mistake how critically important that is to go upstream. but it explicitly recognized different levels of culpability and other mitigating factors. To be clear, the gun safety organizations that advocated for this law were not seeking an across-the-board enhancement without nuance to the sentencing guidelines. I truly appreciate the opportunity to represent this working group, represent Everytown for gun safety, and look forward to your questions.
Thank you, Mr. Wilcox. Vice Chair Murray.
Thanks so much for your testimony, for being here. We appreciate your expertise and willingness to share. I wondered if you had thoughts on Commissioner Roblewski's hypothetical from before. So a friend comes to you and says, can you buy me a gun? I'm a prohibited person and I want to accomplish a burglary. I'm not going to pay you, but we're friends. And you say yes and buy the gun. So there's no remuneration. So under a disjunctive theory of the mitigating factors, you would qualify for the mitigating factors. Do you think you should qualify for the mitigating factors?
I think remuneration on its own is too a limited way to look at kind of role and culpability. I think it is about kind of understanding who the ultimate buyer is and what their intent is. And if the hypothetical is true where an individual knows that there is a potential violent crime that is to be committed, that is a serious factor that I don't think anyone should be taking lightly. And if you look at the directive itself, it asks coercion. And in the hypothetical, we didn't hear that. Domestic violence survivor history, we didn't hear that. Role and culpability, which I just said, we heard knowledge of the future crime. And so in some cases, the lack of remuneration can be incredibly important, especially in cases of domestic violence or other cases of coercion. So I'm not saying to take it off the table, but I don't think it's a simple binary choice where that fact alone would lead to an outcome where we don't see kind of the seriousness of the crime reflected in the guidelines.
So you're not advocating for our proposal in the disjunctive, the or version of our proposal. You're advocating for maybe a third, like a third way.
I think it is clearly a disjunctive. I think that if the language in the directive is a disjunctive, and to read coercion and domestic violence history together means that you have to have both, which I do not think could have been Congress's intent in including that. And if you have a broad term at the end, other mitigating factors, well, if it is a conjunctive, how does a broad term like that ever be met in connection with any of the other specific terms? So I think certainly it's a disjunctive. I'm just not sure that I agree that the lack of remuneration would be sufficient to escape culpability in the hypothetical.
Sorry, I misspoke. You're not advocating for the. Okay. You're not advocating for the conjunctive version of ours.
Commissioner May.
Thank you. First, I want to echo our appreciation for you coming today and for your written testimony. Really appreciate your expertise and thoughts. An issue that's come up a couple times today is the issue of parity, and whether if we increase penalties for straw purchasers, whether we should do that for illegal possession as well. And I was wondering if you could address that point a little bit.
I think the directive was heavily focused on the need to address gun trafficking channels, both straw purchasing crimes and the larger networks that are funneling guns into the hands of prohibited purchases. I think the prior testimony articulated well that to enhance the penalties for those crimes doesn't require an enhancement for the possession crime, and we haven't seen a need for that in how the guidelines have been applied to date. And so I think our position is that those are separate issues, and the directive should truly focus on looking at the gun trafficking and straw purchasing crimes, both the enhancements and the mitigating and fairness factors.
Mr. Wilcox, there's been a lot of talk today about the inequities with respect to racial disparities in this context. Has your group looked at that, or is that not within your purview?
Our groups looked at that, and it's quite concerning. I think we certainly agree with Senators Booker and Murphy in their letter when they explain the intent behind this new provision. And I think if you take a step back, it's important to look at the law in context, the entire law. Where, yes, we had a provision on straw purchasing and gun trafficking that gets to the source of illegal guns, but we also saw a $250 million investment in community violence intervention programs. The first witness, the U.S. Attorney, spoke about some of those efforts to work with communities. And Congress clearly sees that as part of the solution with a significant investment in this law. They also put investment in state crisis intervention programs, extreme risk laws, enhancing background checks, cracking down on unlicensed sellers. Taking that all together, what you see is Congress not looking to exacerbate the racial disparities that we've seen in the enforcement of the law as it existed pre-BISCA. What I believe they're looking for, and Senator Booker and Murphy articulated, is the next chapter, the next verse, which does truly look upstream and looks at how guns are getting into the hands of people who shouldn't have them. And for the guidelines to reflect that, I think we'll go a long way towards both reducing racial disparities and increasing public safety.
You've heard some of the other witnesses talk about delaying, doing some more research, more study, I guess. What is the Zimroth Group thoughts on that?
I think one area that certainly could have increased study is other mitigating factors. That is intentional language offered by Congress, and we know that the Supreme Court has said time and again that they don't offer language in surplus. And what are the other mitigating factors that truly should be considered as part of the downward departure? I think Congress, as I said in this directive, it really is laying out two co-equal directives. To think about the straw purchasers without significant criminal histories that are getting sufficient to deter, and the mitigating factors. And so I think to really understand that balance and have it reflect in the guidelines is an area to study to make sure that the commission gets it right.
Commissioner Wabluski, I think you had a question.
Yeah, I just want to, can I just...
Make sure you speak it up.
I'm sorry. Can I just follow up on the directive? What do you think the words sufficient to deter mean? Because there's been a lot of testimony already about deterrence and about what it means and how effective it is. What do you take that specific language to mean?
Well, I think as mentioned previously, a straw purchaser often won't have prior criminal history, at least sufficient to keep them from purchasing a firearm. And we know that there's 9 specific prohibitions. And I think Congress does want to ensure that those individuals see this as an incredibly serious crime. And it goes to the fact that Congress, to the chair's point, is looking upstream. They're looking away simply from illegal possession, especially illegal possession that may not be connected to violent crime or violent conduct, but are looking to the sources of illegal guns. So I think that is what Congress is getting at, is they want to make sure that the commission is addressing the source of illegal guns, and so that the individual straw purchaser, but honestly the gun trafficker in operations and those who are directing it, as well as the licensed gun dealers, all are within the ambit of the guidelines. But because the sentence is written in 2 parts, that has to be balanced with the second reflect. Right? They use reflect twice in that sentence, which I believe does separate the 2 halves of the sentence. So yes, sufficient to deter is in the first part, but then we have a reflect in the second part that honestly isn't limited just to straw purchasers with limited criminal history. But that sentence, in fact, to me applies to the appropriate amendment.
I get it. So you're suggesting there are 2 sides to this. One is provide the mitigating factors for those who are low level, but then provide something which we say is sufficient to deter, which at least I interpret as the Congress saying what you have now is insufficient to deter. Am I reading that wrong? And do you think a 1 or 2 level increase for that side, recognizing that there's another side as well for the mitigating people, but for the people upstream, the people that you're concerned about, do you think that's complying with it reflects congressional intent that the commission provide increased penalties to sufficiently deter these particular straw purchasers and traffickers?
I think looking at the prior guidelines and the code that was used to enforce the law is a bit of apples and oranges. Because the code that was being enforced for straw buyers was the paperwork violation of lying on the federal form. And now what we have is Congress specifically authorizing prosecution for those who know or have reasonable cause to believe they're buying a gun for someone who's prohibited. And so I think it's very challenging to compare those two since they're quite different crimes. And so I do think what Congress is asking the commission to do is undertake how do you really look at someone in their entirety who is the straw buyer so that they can be deterred in their words, but also you can recognize what may have put them in the position of being a straw buyer in the first place. I think the other big advantage that we now have with the code is lying on the form made it very challenging to get at who was directing the network, who was arranging multiple straw buyers. And so many of the prosecutions for straw purchasing were about just that individual. This new section of the code does allow you to go deeper and get to the person who was arranging and conspiring to set up the entire network, as well as I mentioned, the licensed dealer who's willfully blind to the straw purchase that's occurring in the store. So I think this is a new tool that has broad application to a number of links in the straw purchasing chain, and I think that's the challenging work that the Commission has.
Anyone else has any questions for Mr. Wilcox? Okay.
I have one more. I just wanted to follow up and just make sure I was clear in understanding one thing regarding the mitigating factors. And your suggestion is that we include a reduction for a subset of individuals and then a broader departure as well, so kind of a two-part approach to mitigating circumstances. Am I understanding that correctly, or is there, or not?
It's a great question, and I apologize for any lack of clarity. But I read that sentence as really having two ideas in it that the Commission then has to take up. It's an appropriate amendment to reflect the intent of Congress, and then you have the enhanced language, and then an appropriate amendment to reflect the defendant's role and culpability, which is one. Then we have a conjunctive and any coercion, domestic violence, survivor history, or other mitigating factors, a disjunctive. I actually think it's a quite complicated sentence, but it does, I think, require for any of the amendments that relate to trafficking and straw purchasing to look at role and culpability and then the other factors, coercion, domestic violence, other mitigating factors. And so as I'd be thinking about the amendments, I'd be really trying to parse this language carefully, apply it broadly, and give full weight to what Congress was quite novel and deliberate in doing, which is, for I think one of the first times, instructing the Commission to look specifically at these type of mitigating factors. And they certainly didn't list them all, and they certainly didn't get it all right, and I think that is the value of the Commission, is to dig deep and really give meaning to these terms.
Thank you, Mr. Wilcox, for your testimony. We're ready for our next panel.
Thank you so much.
Thank you, sir. Now we're about to move to our next panel. I'd like to introduce our fifth panel, which will present the executive branch's perspective on our proposed amendments regarding what we define as fake pills and First Step Act drug offenses. To present that perspective, we have with us the Honorable Carla Friedman, who is the first woman to serve as United States Attorney for the Northern District of New York. Ms. Friedman is the chair of the Controlled Substances Subcommittee of the Attorney General's Advisory Committee. Ms. Friedman has over 30 years of experience prosecuting organized crime, violent crime, and drug offenses as a state and federal prosecutor. Ms. Friedman, we're ready when you are.
Chairman Reeves and members of the Commission, thank you very much for the opportunity to appear before the Commission to discuss the problem of fake pills. I want to thank the Commission for working with the Department, including the DEA, to address the ongoing crisis of deaths from fentanyl poisoning. As you know, subsection B13 of section 2D1.1 currently provides a 4-level enhancement when the defendant knowingly misrepresented or knowingly marketed as another substance, a substance that in fact contained fentanyl or a fentanyl analog. In response to concerns over the usefulness of this enhancement, the Commission has proposed an alternative two-level enhancement with a lower mens rea. That is, where the defendant had reason to believe that a substance that the defendant represented or marketed as a legitimate drug was not legitimately manufactured and the substance in fact contained fentanyl. The Commission has also published as an issue for comment application of this enhancement to other synthetic opioids. First, regarding the mens rea requirement, the current enhancement applies so infrequently in part because it requires proof that the defendant had actual knowledge that the substance contained fentanyl or a fentanyl analog. This actual knowledge standard is higher than the mens rea required for a Section 841 drug trafficking conviction. Although it is common knowledge that among drug traffickers that most fake pills contain fentanyl, it is often difficult to prove that the defendant knew the specific pills that he or she trafficked contained fentanyl because defendants claim ignorance of the pill's contents and because they use vague, coded language when discussing the drugs. Even when fentanyl was sold in baggies, the enhancement rarely applied. Now that fentanyl is so often sold in pill form, the enhancement is even harder to apply. To reflect this reality, we recommend a rebuttable presumption. That is, the enhancement should apply presumptively, but a defendant can show that he lacked actual or constructive knowledge, with the defendant bearing the burden of such proof. Such a rebuttable presumption would properly reflect the fact that drug traffickers should know that there is an extremely high probability that the black market pills they are selling contain deadly fentanyl, and that any proof that the defendant had no reason to believe they contained fentanyl lies primarily with the defendant. If the Commission instead adopts a reason to believe standard, it would be helpful to define that term. One option would be to define the term to require specific and articulable facts combined with reasonable and common sense inferences from those facts that provide an objective basis for believing that the pills are not legitimately manufactured. The Department also recommends that the Commission amend the requirement that the defendant market or represent the drug as legitimate. Unfortunately, this formulation does not reflect the reality of a market flooded with pills that look like legitimate prescription drugs, such as pills in various colors that are marked M30 to look like oxycodone. And as currently written, the enhancement might apply more regularly to street-level dealers rather than to the high-level traffickers who distribute fake pills without making any representations about their content. We thus recommend that the enhancement apply not just when a defendant represents or markets the drug as legitimate, but also when the offense involved a substance that would appear to a reasonable person to be legitimately manufactured. Finally, the Commission has asked whether B13 should be broadened beyond fentanyl and fentanyl analogs to include synthetic opioids. It should. Although the vast majority of fake pills contain fentanyl, the DEA has seen an increasing number of fake pills with other synthetic opioids. If, however, the Commission elects to focus on fentanyl and fentanyl analogs for the time being, we ask that you monitor the situation during the 2023-24 amendment cycle and propose additional changes to address all synthetic opioids as appropriate. Thank you.
Thank you, Ms. Friedman. I turn now to my fellow commissioners.
Just, Ms. Freeman, following up on, I don't know if you heard Judge Gleason's question earlier. It's the same question, really, with respect to this rebuttable presumption and the impact it would have on an individual jeopardizing acceptance points, a judge finding obstruction points, and any Fifth Amendment concerns. I mean, has the department thought this through in terms of putting the burden on the defense?
We have, Vice Chair Restrepo, and I appreciate the question. I would point out, as my colleague, U.S. Attorney Gary Restrano pointed out, the concept of a rebuttable presumption is not new to the guidelines. It exists in 4 separate areas. And the department's position focuses on the fact that this is such a well-known concept now, that these pills that mimic legitimate prescription drugs oftentimes, most times now, in fact, are containing fentanyl. And to put the burden on the government to establish whether or not the defendant knew is really, in many ways, unfair and impossible. As I'm sure Your Honor is aware, frequently in drug trafficking, particularly at higher levels, there is no conversation. I can't tell you the number of wiretaps that I've listened to where the most you hear is a number and a meetup. And so it's very difficult to apply this enhancement where the government bears the burden of establishing the mens rea. And we're not suggesting that there be no mens rea. We're giving the defendant, who's in the best position to have a defense, an excuse, a reason why he or she had no idea that the pills contained fentanyl, to provide that to the court and for a judge to be able to consider that.
Ms. Friedman, one of the comments from the Practitioners Advisory Group argued that the reason to believe standard here is akin to strict liability. And the concern generally would be that this language could encompass anyone based on sort of generalized risks, generalized knowledge in the community about the risks of fentanyl. What is your response to that? Do you think the current proposal does sweep in the entire universe here? And are there ways to tailor the language that you think would sufficiently target a more nuanced recklessness standard here than what's currently drafted?
Thank you, Commissioner Wong. I appreciate the question. I would say that, first of all, it's actually not strict liability. I would also point out that there are several enhancements currently in the guidelines that are offense-based, or more particularly strict liability. For example, we've heard this before. Under 2K 2.1, if a firearm is stolen or the serial number is obliterated. There's also examples with respect to drugs. The distribution of a controlled substance in a prison setting is an automatic enhancement. The distribution, I had to look this one up, of steroids with a masking agent. Also, I don't know that we see that often, but there are, in other words, prior examples in the guidelines currently for strict liability. This really isn't. This is providing, it's taking what's so widely known now about the pills that look like legitimate drugs, but in fact contain fentanyl and are killing people at alarming rates. And it recognizes that tragic and scary fact and still allows for defendants who are perhaps wrongly caught up and really had no knowledge, the ability to not be strictly liable, but to present their evidence, and again, only by a preponderance. That's the standard, to present it to a judge for consideration. Quite frankly, the proposal that the department is putting forth, you talked about or asked the question about encompassing people who shouldn't be encompassed. The goal here is really to get at higher level drug traffickers, and quite frankly, as written, and I appreciate, the department very much appreciates the commission's recognition that the current 4-level enhancement is not addressing the problem that we have now. And in recognizing that, you've proposed a 2-level enhancement to make that a workable and functional enhancement that actually reaches out to the people who are higher level, the true drug traffickers. The government believes that our proposal would encompass that, while still, I should say, offering protections, as I say, with a rebuttable presumption for those who should not get the enhancement.
Good morning. Thank you for your testimony. In thinking about this mens rea component and how the government would prove the knowing standard, is there, this is a fairly technical question, is there, I would think, a pretty significant difference between the street value of a real oxycodone, an Oxy 30 pill, and a manufactured synthetic one that contains fentanyl? I presume the latter is significantly less expensive? But I'm just presuming, so I don't know for sure, if you know.
I think the DEA would be in a better position to answer the price point variance, but I would say this. One of the things that is so frightening, and I think that has led to us being in what is clearly a crisis nobody can deny this, is the fact that fentanyl is so cheap and easy to make. Unlike heroin, obviously, which is a plant, and so you can only have so much of it because it is plant-based, there seems to be an endless supply of the ability of, in particular, Mexican cartels to manufacture this. So I'm not sure whether, in fact, a fake oxycodone pill that contains deadly amounts of fentanyl is, in fact, cheaper than the black market true M30 or oxycodone pill. But I think that's what makes this so frightening right now, is that there are people from teenagers and kids to the elderly trying to get a black market oxycodone. And instead, they're ending up with a pill that in fact looks like oxycodone, but contains deadly amounts of fentanyl.
Yes.
Thanks so much for being here, Ms. Friedman. I had a question about your written testimony regarding Guideline 5C 1.2, and in particular the floor. You know, there's this issue about whether the floor to 5C 1.2 should be set at base offense level 17, or if it should be set to the guidelines range. And the department's position seems to be that you need to keep it at base offense level 17 in order to make sure that floor applies in a kind of graduated way to people with lower and higher criminal history. And I'm wondering why the guidelines themselves, apart from the floor, don't already do that work.
Vice Chair Murray, I very much appreciate the question. And while I could spitball, the department would probably be not happy. I have been focused on addressing the fake pills. I do believe that one of my colleagues, Carmen Mitchell, who is going to be speaking about the circuit split, may be able to address that.
Okay, great, thanks.
Has Congress asked us to do anything with the fake pills issue specifically?
Chairman Reeves, I'm not aware of them doing that specifically, but I will say this, and I was thinking about this a little bit earlier with all the conversation about Congress and firearms and where their priorities are. In my role as chair of the Controlled Substances Subcommittee, one of the many tasks that I am tasked with is reviewing proposed legislation both from the House and from the Senate. And I am struck with how many potential bills are coming from both sides of the chamber, both House and Senate, trying to address the fentanyl crisis. I've seen legislation where and none of them are looking for a less severe punishment. I've seen proposed legislation. I mean, we currently, as the Commission is well aware, we have mandatory minimums for certain thresholds of fentanyl and fentanyl analogs, and obviously even from death resulting from these drugs or other drugs. The proposed legislation that we've reviewed is looking to increase the penalties. I've seen things wanting to label the cartels as terrorist organizations. So certainly the mood that I'm seeing from the legislation that's making its way across my desk talks about a recognition by Congress about how severe the problem is with fentanyl and fentanyl analogs, but in particular fentanyl, and trying to address that in the best way possible. I know the Commission has proposed a 2-level enhancement that didn't previously exist, and the Department endorses that as at least a small measure that may address one particularly dangerous and insidious aspect of the fentanyl crisis, which is not just selling fentanyl that in baggies where the consumer may think that he or she is getting heroin, and that I believe was one of the issues that the Commission confronted in 2018 when they promulgated the 4-level enhancement. Who could have envisioned that 5 years later, we are now seeing, whereas I believe DEA's latest statistics were there were 3 million pills seized in 2019. Last year, there were 61 million, from 3 million to 61 million fake pills seized. These numbers are astronomical. And obviously, as the Commission is well aware, the number of people dying because they thought they were taking a Percocet and instead they were taking a pill with a deadly amount of fentanyl, and it takes just so little. This is something that clearly, if a 2-level enhancement will help save some lives and properly punish those people involved in this insidious conduct, I haven't heard Congress speak about it, but clearly the impression that I'm getting is that this is a serious problem that Congress wishes to address.
do you see any parallels between this and Congress's efforts years ago to address the crack epidemic, and how did that work out?
That's an excellent question, and obviously I didn't sit in Congress then, didn't sit now. I'm aware of some of the discrepancies that have happened. I'd like to point out that, as the Commission is well aware, the discrepancies among the Black and Brown community with respect to crack is well recognized. And although there was legislation proposed, the Equal Act, that in fact has not passed Congress, the Department has tackled this. And regardless of the fact that legislation didn't pass, and quite frankly, the guidelines right now don't still have the disparity between powder cocaine and crack cocaine, the Department no longer recognizes a distinction. The Department is aware of the empirical evidence, the Department is aware of the racial disparity, and has taken it upon themselves, at the direction of Attorney General Garland, to the entire department, that we now treat powder cocaine and crack cocaine the same. So we are aware, and to the extent that there is evidence-based reasoning, and certainly issues of racial disparity, I believe that the department tries to address that. One of the things that's I think, fundamentally different about fentanyl is, number one, even based on the statistics that the Commission has, the racial disparity is not the same as it is for powder cocaine or crack cocaine. And when we think about the victims, they cut across all races and ethnicities and ages. There is not a state that has not been affected by this opioid crisis, and in particular, the opioid crisis in the form of deadly poisonous pills.
So I understand that the department prefers a rebuttable presumption of mens rea. If we were to keep the mens rea the way it is, in terms of reason to believe, and perhaps flesh it out with examples the way you suggest, do you think that would end up being helpful, significantly helpful, in terms of the department's efforts to fight this scourge? Or is it relatively minimal unless we adopt the rebuttable presumption?
Vice Chair Murray, obviously the department would welcome anything to help us in this fight, and anything we can do to make some sort of an impact on this crisis. We certainly believe that we would have a greater impact and a better ability to hold those people accountable, particularly the higher level people that really should be held accountable, if the Commission adopts the proposal that we've given with a rebuttable presumption. But if for whatever reason the Commission felt that was not appropriate, obviously a reason to believe standard is more likely to at least encompass the ability to prove some of these drug traffickers and pill pushers pushing deadly fentanyl than the current standard, which I would point out, since this was promulgated, I believe there have been 5,700 fentanyl drug traffickers sentenced. Of that 5,700, that 4-level enhancement, the only enhancement we currently have, applied 57 times, which I think comes out to 1%, though math is not my strong suit.
I'm looking back at your written testimony, I believe, where you talk about section 2D1.1B13 should be broadened. And I see some language where you say, but the most critical data point on which the Commission should base its decision is the CDC estimate. I think this is your testimony. And you go on to say, we ask the Commission to monitor the situation during the next amendment cycle and propose additional changes if appropriate. I may be reading from the wrong testimony. I thought it was yours. And I was just going to ask, is there any need for the Commission to sort of, look at this issue, get more empirical information about expanding or broadening fake pills, something beyond fentanyl or whatever?
I appreciate the question, Chairman Reeves. The department would certainly ask and believes that there is enough empirical data so far provided by the DEA and other agencies to demonstrate that not only fentanyl and fentanyl analogs, but other synthetic opioids should be included. I'm not a chemist, and I'm sure I'll pronounce this wrong, but things such as nitazines, which are other synthetic opioids, are being included in many of the prescription pills, although clearly the vast majority still contain fentanyl. So to solve the problem in a holistic way, we would certainly ask that you include the language of other synthetic opioids. Again, as a fallback position, sort of as I said before with respect to the reason to believe standard, something needs to be done. So if at this point the Commission isn't comfortable in including all synthetic opioids, we certainly would appreciate the enhancement, the two-level enhancement as written by the Department that includes at least fentanyl and fentanyl analogs.
Thank you.
I have one follow-up question. This is kind of related to the crack question earlier. Congress and the Commission for years have tried to solve various drug crises within this country by increasing sentences. And I think we can look to recent overdose deaths and the rate of those as indication that we've failed in that regard. Is there some reason to think that this particular change would be different and bring success that we haven't seen in the past?
I think the critical, it would be ridiculous for me to argue that this was going to fix the problem and that we'll immediately see overdoses go down. I know from a department standpoint, we understand we are not going to prosecute and arrest and jail our way out of this problem. And prevention and deterrence is equally important to the department, and we are trying as best we can to do that. What I would say about this, unlike the current problem with respect to fake pills, unlike all the other drug problems that we've seen, is that these are pills that are designed to look like something else, like oxycodone. Is it right for somebody to be buying a black market oxy pill? No, it's not. Is it a crime to sell a black market oxycodone pill? It is. The problem is that we are masking, these drug traffickers are masking what looks like oxycodone, Percocet, Xanax, Adderall, with deadly fentanyl. And it takes so little for it to be deadly. It looks appealing to children. Sometimes it looks like candy. They're colorful pills. For people that might have been reluctant to inject something into their body or snort something into their body, this is a pill. And we're hearing every single day about another teenager or youngster. And I don't mean to just focus on them, but the entire age range of people who think that they're getting black market oxycodone pills. I keep focusing on that because that's the majority, when in fact they're getting fentanyl. And that's the difference.
I take it no additional questions for U.S. Attorney Ms. Carla Fried. Thank you so much for your testimony.
Thank you.
Oh, I'm sorry. Aha. Judge Gleason Commissioner Gleason has a question.
Thank you, Judge.
All right.
Yeah, my question is whether, I mean, you can't help but feel the increased culpability of offenders of the sort just described, and thank you for your remarks, by the way. But my question is whether there are insufficient tools already in the toolbox of sentencing judges to mete out sentences that are commensurate with that increased culpability, and the degree to which there's a need to tinker with the guideline ranges in order for that to happen. Obviously, the department feels there is, but I'm just curious whether by way of departures or variances or other tools that judges have, whether there's a felt need for the guideline ranges to be higher as well.
Thank you, Judge Gleason, for the question. I guess my first answer is that we can never have enough tools in the toolbox, so we appreciate even one more. But that being said, I would make this important distinction. There are, of course, tools to prosecute fentanyl and fentanyl analog trafficking, like all drugs. The difference here is that we are not, and judges are not able to treat the person who knowingly sells a pill that looks like oxycodone but has fentanyl in it any differently than the drug trafficker who's got a little bag of heroin or fentanyl and even indicates that he or she is selling fentanyl to a willing buyer of fentanyl. That person, where to some degree both the seller and the buyer understand the transaction and the danger that they're engaged in. Now, when someone is selling a pill and marketing it, or representing it, or saying nothing at all, but just from the way that the pill looks, the buyer believes that he or she is getting a Percocet, but in fact they're getting fentanyl. And that is a huge difference that right now there is nothing that a judge can do unless somehow the government is able to show that the trafficker, and in this case it would likely have to be the street level trafficker, we can't get at the suppliers to those traffickers, knowingly misrepresented and knowingly marketed that. That's a standard that even though this is happening day in, day out in all 50 states, I think the numbers bear it out. That application, that enhancement's been able to be applied 1% of the time, while the number of pills have gone from 3 million to 61 million.
Thank you.
Thank you, Judge.
Thank you, Ms. Friedman.
Thank you.
Thank you for your testimony. We're ready
you.
for our next panel. Our sixth panel provides us with the federal public defender's perspective on this issue. To present that perspective, we have with us, Michael Caruso, who has worked as a federal defender for nearly 30 years and currently serves as a federal public defender for the Southern District of Florida since 2012, when the 11th Circuit Court of Appeals appointed him to that position. In that capacity, Mr. Caruso supervises over 50 assistant defenders who handle a wide range of cases, including those involving narcotics. Mr. Caruso also serves as chair of the Federal and Community Defenders Sentencing Guidelines Committee. Mr. Caruso, we're ready to hear from you, sir.
Thank you, Chair Reeves, Vice Chairs, and Commissioners for inviting me to testify today on first step implementation and counterfeit pills. While the three proposed amendments addressed today are distinct in many ways, our position for each of them shares the same bottom line. Do not promulgate amendments that would unnecessarily increase sentences for drug offenses and unnecessarily complicate the guidelines. Section 2D 1.1, as you know, is one of the most highly criticized and consistently rejected federal sentencing guidelines. Sentences imposed within the guideline range produced by 2D 1.1 are diminishing. Last year, only 28% of cases under this guideline were within the range, with nearly all cases sentenced below. For more than a decade, federal judges nationwide have called for 2D 1.1 to do a better job at recommending sentences that satisfy 3553A. For example, courts around the country have recognized the unwarranted disparity between the methamphetamine mixture and purity guidelines. In the Third Circuit, a lawyer is ineffective not to request a Kimbrough variance from the MDMA guideline. And even in the face of the opioid addiction crisis, the fentanyl and analog guidelines are so severe that in 2021, courts imposed below guideline sentences in 36% of fentanyl cases and almost 50% in analog cases. Above guideline sentences, by contrast, were rare. In the face of this sustained criticism, 2D 1.1's unwarranted harshness, defenders oppose any amendment that would increase penalties under this guideline any further. Such amendments would be contrary to the spirit of the First Step Act and would be contrary to our lived experience that we cannot punish our way out of a public health crisis. Turning to the specific proposals the Commission is considering. First, safety valve implementation. The Commission should not substantively limit safety valve relief in 2D 1.1 and 2D 1.11. This is particularly true given the Supreme Court's decision last week to resolve the conflict as to how the circuits have been interpreting this new law. The Commission should not take any action that would appear to weigh in on this litigation and should instead wait for the Supreme Court. Second, 2D 1.1 enhanced base offense levels. The Commission does not need to promulgate the proposed amendment to account for the new statutory definitions for serious drug felony and serious violent felony. Instead, we ask the Commission to delete those provisions that we submitted in our written testimony entirely and let the few cases that would normally be assigned those base offense levels play themselves out. The guidelines and statutes already provide sufficient increases for when a person commits a drug crime resulting in death after previously sustaining a prior conviction. These base offense levels are frequently misapplied, and deleting them would be the simplest way to account for the new First Step Act definitions and would better ensure that people are only being subject to enhanced base offense levels if they are also subject to the enhanced statutory penalties. Third, counterfeit pills. We urge the Commission to reject the proposed two-level enhancement. Defenders do not dispute that our country faces a public health crisis and that drug addiction and overdoses pose critical public health challenges. We have learned, however, as Ms. Friedman just said, that ratcheting up criminal penalties in response to such challenges does not remedy them. It does, however, result in unjust punishment that takes years to unwind. As the Commission recognized last cycle when it rejected a strikingly similar proposal, the proposed enhancement lacks an adequate mens rea requirement that we've talked about today. This standard proposed would fail to distinguish between different gradations of conduct and culpability. And as DOJ has recognized in its letter to the Commission, the reason to believe standard has already proven difficult to apply and would likely spawn confusion, litigation, and unwarranted disparity. The proposed amendment would also entrench broad negligence-based sentencing in the guidelines, right as the Supreme Court has repeatedly re-emphasized the fundamental importance of mens rea in our criminal legal system. Indeed, the Department's most recent letter to the Commission has already foreshadowed the government's litigation strategy should this proposed amendment be promulgated. The government would argue that the presence of fentanyl in counterfeit pills is so well known that this enhancement should apply in every single counterfeit case. The dangerousness of fentanyl and its analogs is already more than captured in the drug guidelines and the statutes, and history and data confirm that increasing penalties in these cases would not reduce the availability of counterfeit pills or mitigate our country's increasingly tainted drug supply. I heard Ms. Friedman concede today that adding a +2 level upward adjustment would not cause one overdose death to be avoided. For these reasons, the Commission should not promulgate this amendment. I welcome your questions.
Thank you, Mr. Caruso. Turn to my fellow commissioners. Yes, V.C. Burr.
Thank you, Mr. Cruz. I found your testimony, as I always do, very helpful.
Thank you.
I had a question about 2D 1.1. I mean, as you know, we are not required to tether 2D 1.1 to the statutory safety valve. So we have the, query the wisdom, but we have the power to tether or untether 2D 1.1's safety valve to whatever the Supreme Court decides in Pulsifer. So I guess one question I have is, in terms of just kind of implementing congressional intent, maybe there's a Scrivener's error or something, but is there any real way that we can think that Congress intended for the safety valve factors to be, let me get this wrong, conjunctive? And the reason I ask that is that, you probably saw in the preamble to our amendment, we kind of lay out the numbers there. Of 17,500-ish drug traffickers, if the factors are conjunctive, only 300 people don't qualify for the safety valve. Like, everybody qualifies for the safety valve. And it almost seems like an elephant in a mouse hole, right? Now, obviously, Congress intended for it to be broader, right? And I think the numbers are, the old safety valve would be 4,000. All but 4,000 would not qualify, and disjunctive 2,000 would not qualify, and then 300. It just seems so low. Did Congress intend to get rid of mandatory minimums in the drug context altogether? Wouldn't we have seen more? So I guess I'd love your thoughts on that.
Yes, and I appreciate the question, Vice Chair Murray. One, I'm not in a position to say that Congress makes Scrivener's errors in important statutes like this. Two, I think we should also step back and recognize, I think you have, and as the commission has, that the spirit of the First Step Act was to reduce the severity of the guidelines, as almost everybody, including this one, has recognized. And while we might debate other terms of art and whether Congress had made a mistake, when we're talking about the words and or, I think we're in completely different, a different category. You know, for better or for worse, I'm a product of Florida State Public Schools. And, you know, for me, and has always meant conjunctive and or has always meant disjunctive. And I don't see how Congress could think otherwise. You know, as you know, I practice in the 11th Circuit, so anytime I have an opportunity to stand shoulder to shoulder with Chief Judge Pryor on an issue, I embrace that opportunity. And, you know, I think, obviously, he was the author of the en banc Garcon majority case, and I think he, in our mind, presents a compelling statutory construction case as to why and means and I can go through those if I need to, but I think you're well familiar with that opinion and all the canons of statutory construction that he discussed. Thankfully, the Fourth Circuit recently in Jones essentially provided an executive summary of the issue, which has also been helpful. So, you know, I think we should wait and see what the Supreme Court does. That being said, if the commission does not want to wait and see for all the reasons Chief Judge Pryor set forth, we do think and is the superior reading. The one final point I would put to the commission as to you approach this issue. So under an advisory scheme, and I'm not telling you anything that you don't know, the commission's power is in its legitimacy and credibility. And, you know, I'll compliment today in this public hearing the research and data exploitation that this body does. It's tremendous and helpful to practitioners and to judges, I believe. But I think weighing in on this issue, certainly now, once the Supreme Court has decided to take up this case, probably to be argued in October, a decision shortly after that, we think the most prudent course is for the commission to wait and see.
Can I follow up on that?
Yes, you may.
Can I follow up?
Of course.
Implicit, though, in your answer is that the commission has the authority. You may not think it's wise, but I just want to clarify that. Am I reading it right that you believe the commission has the authority in 2D11, not in Chapter 5, but in Chapter 2, to give its own policy judgment and reflect that within its decision whether to use and or whether to use or? Am I getting that right? And then, if I am getting that right, what does it matter what the Supreme Court says? So the Supreme Court says Congress meant and, they said and, they meant and. Okay, then it still comes back here, and doesn't the commission still have a policy judgment to make as to what is the right policy for the two-level adjustment in Chapter 2?
So to answer the first part of your question, I think we do believe that, you know, under your broad-based powers, this body has authority to make policy under the guidelines. But to answer the second part, I'm going to refer back to my answer to Vice Chair Murray, why you wouldn't want to do that, because imagine, and we talked a lot today about disparity. Well, think about the disparity that would occur if the Supreme Court decided that and means and, but this body decided that and means or. We would have, you know, circuit conflicts about who would you know, be eligible for the mandatory minimum versus who would not get this benefit under the guidelines. You know, I think that would just cause chaos, and I do wonder what the judges in my circuit would do, you know, with regard to not only as the Supreme Court weighed in and said and means and, but also the circuit previous had done and. There would be a real dissonance between sort of ordinary canons of statutory construction and the Commission's policy making. And I think if I were a commissioner, I'd be very worried about the perception of this body's legitimacy if you go down that road.
Can I ask one other question?
Yes.
On a different subject. So you're suggesting that the commission strike from the guidelines the recidivist provision. And you say that the statutes can take care of it. I'm sure you're well aware that Attorney General Garland directed prosecutors not to charge mandatory minimums, including recidivist provisions in most situations. And I'm curious, do you really want the government to be charging those? Do you want them to be stricken from the guidelines and then the government to be charging those enhancements, the statutory enhancements that would apply? Is that really your preferred policy?
That is not my preferred policy, but I'm old enough to remember the Holder memo, and in my district, how that memo was not strictly followed by line AUSAs. I think this is a real issue, and Ms. Friedman referred to the part of the charging memo regarding crack cocaine. Attorney General Garland issued these memos, and we're very pleased with the provisions of those memos, in particular, the not charging mandatory minimums. It's yet to be seen how that plays out district from district and whether that guidance is followed, because I think we all can agree that there's no mechanism in my district that if the U.S. Attorney is not following the Garland memo, that I can take an appeal to Maine Justice. So whereas I agree what Attorney General Garland said is good policy, I think it's too soon to say how that's going to play out on the ground.
Vice Chair May.
Thank you. Thank you for your testimony today. We appreciate it. I have a follow-up question on the 2D and the striking. If we didn't strike 1 and 3, but wanted to make clear that those enhanced base offense levels only apply based on offense conduct, is the language we have in our proposed amendment adequate to accomplish that, or is there different language we should be looking to?
So thank you for that question. So I think the language you should be looking to is found in 1B 1.2a, and that provision provides you determine the offense guidelines section in Chapter 2 applicable to the offense of conviction, i.e. the offense conduct charged in the count of the indictment or information of which the defendant was convicted. We think that type of language would present more clarity because, as you know, in our statement, while we say on the one hand that the work that these base offense levels do is contained in other guidelines and statutes, they are misapplied, and we would want to, if you don't eliminate them, to make clear that it's based on the offense of conviction.
Commissioner Wong.
Mr. Caruso, just to shift gears a bit back to the pills, U.S. Attorney Friedman painted the contrast or the need to differentiate between two scenarios, and she talked about where there's sort of a knowing buyer and seller of an illicit substance, and what's very predominant in the fentanyl context, which is this misrepresentation idea where 2 milligrams is a lethal dose, but it's packaged in a non-lethal form of controlled substance in pill form. And of course, here what's interesting is we're not writing on a blank slate. The Commission, with the currently drafted enhancement, appear to be trying to get at some kind of that differentiation. And I'm curious if you think the fact that it's only been applied about at a 1% rate because it is very difficult to qualify, is that sufficiently getting at that, I think, compelling interest in differentiating between those two scenarios?
So I think my answer to you may sound like questions to you, and I don't mean that. But on the one hand, I haven't seen the data about how many times the government has sought this enhancement and failed. So I would like to know that information, because just knowing in the abstract, if a probation officer hadn't recommended that enhancement, if the line AUSA hadn't asked for that, and it was denied because of a lack of evidence, I would want to know that. But also I think, we don't, like, as a trial lawyer, when I hear, Ms. Friedman's testimony, when I read the Department of Justice's written testimony, I just think that there is a fundamental disagreement about if the fact was true, how hard this would be to prove. Prosecutors all across the country every day have to prove up knowledge in a variety of contexts. I know Ms. Friedman talked about wiretaps and drug traffickers being wily and not talking to them about on the phone. To be clear, those are not my clients. I have not seen a fentanyl or an analog case that is dependent on wiretaps. What I do know is my clients often carry iPhones and other cell phones and do to their detriment text frequently with the people that they're conspiring with and selling with. So they also have that source. The prosecutors would have that source of evidence to present to a court. Also, for better or for worse, when my clients are arrested, most of them waive Miranda and speak to the police. These are certainly questions that could be asked in interrogation, along the lines of, did you know what you were selling was real or fake? And that's another avenue for the government to marshal proof to get this adjustment. And finally, with regard to, I believe this was in the department's written testimony, and Ms. Friedman represented it earlier today, the use of coded words. And again, for all the lawyers here and judges, we know that the government frequently employs experts, usually in the form of law enforcement agents, to decode the code our clients think they're using. So I think I think prosecutors do have all those avenues to prove up knowledge. Whether they're trying that and being rejected or just not trying, I don't know, and I would want the answer to that question before we embark on a new adjustment.
I very much took, on the pills front, I very much took your point about the point of the enhancement should not be just that, it's in the air, everyone knows that every oxy could be fentanyl at this point. I know you don't think we should go forward with the pills enhancement, but if we were to go forward and we were to stick with the reason to believe standard, are there factors you think it would be useful for us to kind of flesh out as examples in an application note? Or the department has a list. I don't know if you have thoughts on what would be useful.
So first, and thank you for, I think you've noted the sort of cognitive dissonance of, Ms. Friedman's testimony, where she said there are unsuspecting buyers, coupled with everybody knows that counterfeit pills have flooded the market. So I think that's a real issue that the commission has to grapple with, and whether this is going to make any appreciable difference. But the standard that the Department of Justice, has proposed, I think, in addition to be contrary to recent Supreme Court cases like Ruan and Rahafe, is also unworkable, because as I understand the standard, there are two parts. One is, present with regard to every sentencing issue that the party has to prove by a preponderance of evidence. So that means more likely than not. So now this new rebuttable presumption involves reason to believe. So defense lawyers would be in the position of having to prove that it's more likely than not our clients did not have a reason to believe.
Sorry. Can I interrupt you? I was saying maybe I wasn't, in the event that we reject the government's proposal, we stick with the reason to believe with the burden of proof on the government proposal that we had initially promulgated, not the government's giving the burden.
And I apologize for misunderstanding. I don't believe that there could be any factors that the commission could flesh out, again, because I think if this adjustment goes forward, the default, there will be a default and an almost automatic +2 in all of these cases, again, because, as we heard, as the defenders acknowledge, as the department acknowledges, this is so commonplace that everyone knows. So for us our clients not to receive this adjustment would just be nearly impossible, and it would essentially just be, a new base offense level for counterfeit pill cases.
So you think in general your clients do know that they're probably marketing fentanyl?
I can't. Obviously, I'm not here to break attorney-client privilege, but I think, you don't have to be a lawyer, a judge, or a commissioner to know that we're in the midst of a significant public health crisis. It's in the newspaper. It's on TV nearly, every week. I think the public is well aware that our drug supply has been tainted, and that there is a risk that whatever pill they're buying on the black market may not be what they think they're buying.
So, I guess your point there then, it sort of adopts part of the Department of Justice's reasoning, which is everybody knows, and so it's just buyer beware, or I guess some of the, the data demonstrates that 70%, I think, of all overdose deaths in the United States are fentanyl deaths. And so how do you've acknowledged, I think everyone will keep generalizing, everyone knows there is a public health crisis. So, what do we do about that?
So I think there's what the big we and what the small we does. So the big we, I know I listened to President Biden's State of the Union address, and I'm appreciative that he raised the point about this crisis. But I think we also know that this is a public health crisis. So when you look to federal government agencies like the Centers for Disease Control and what they're doing, when you look to state and local health agencies to see what they're doing, that is us trying to tackle this problem. I got from Ms. Friedman's testimony today, and I feel it too, it's not just her, a sense of helplessness. People are dying. This is a serious issue, but it's a multifaceted problem that the criminal legal system really cannot address. And we know that from decades of experience. Again, in the last 10 years, I've been part of both national and local efforts to unwind a lot of these unwise drug policies. For example, President Obama's Clemency and Commutation Initiative, Drugs -2, First Step litigation. So we believe that the federal government as a whole needs to work on this issue. What we're saying is that history has taught us, and my colleague Ms. Scott spoke eloquently about that this morning, that we can't punish our way out of this crisis. And I heard Ms. Friedman to concede that earlier today. And again, your fentanyl report issued recently is an amazing piece of work. On pages 10 to 12, I think you all set forth all the statutory and guideline provisions that are out there already to punish fentanyl and fentanyl analog traffickers. And at the end of the day, it is up to, each AUSA and each defense lawyer to advocate under 3553A for a sentence, and it's up to the judges who have been appointed and confirmed, and we trust to reach those decisions. And, I would, in addressing this issue, I would also, ask you to look at the racial disparity of the people who are being sentenced under these guidelines. I think I do disagree with Ms. Friedman when I thought I heard her say that there was not a disparity issue here. I think the data will show that the defendants prosecuted in fentanyl and fentanyl analog cases are primarily people of color. We know that judges are varying downward in those cases, but ultimately, at the end of the day, the Department of Justice and U.S. attorneys have adequate tools to address this problem from a criminal legal system standpoint.
Any further questions from Mr. Caruso? Thank you, Mr. Caruso, for your testimony.
Thank you.
Our seventh group of panelists will provide us with perspectives on this issue from two of our advisory groups. First, we will hear from Marlo Cadedu, who serves as the Fifth Circuit's representative to the Sentencing Commission's Practitioners Advisory Group. Ms. Cadedu is a solo criminal defense practitioner who handles federal cases across the nation. Ms. Cadedu has previously served as a steering committee member of the American Bar Association's Death Penalty Representation Project. Second, we will hear from Jill Bushaw, who serves as chair of our Probation Officers Advisory Group. Ms. Bushaw serves as Deputy Chief United States Probation Officer for the Northern District of Iowa. She joined the U.S. Probation Office in 2003 and has previously held positions as a sentencing guidelines specialist and as a supervisory and assistant deputy chief in the pre-sentence investigation unit. Ms. Cadedu, we're ready to hear from you.
Thank you, Judge Reeves, and thank you, Commissioners. I'm afraid you're going to be seeing me 3 times today.
That's not enough.
Oh, I think it's plenty. I represent the PAG, as you know, which is a group of private practitioners who represent criminal defendants. We very much appreciate the opportunity to present our views to PAG on these issues. Today I'll be talking about fake pills and First Step Act drug offenses. I'll start with fake pills. The PAG understands the DEA's concern about the proliferation of fake pills that contain fentanyl and the public's concern about the sharp increase in deaths related to these synthetic opioids containing fentanyl. Based on PAG members' experiences with the drug guidelines, however, we cannot support the new 2-level enhancement proposed in 2D1.1b13. First, it is unclear what evidence supports the creation of this new enhancement with its reduced mens rea standard, other than increases in the availability of fake pills and the increase in overdose deaths, which are, we all agree, horrifying and certainly a public health crisis. There does not appear to be any evidence-based reason or empirical basis for establishing this new 2-level enhancement. The Commission has not explained what correlation there is between this new enhancement and the DEA's concerns. Second, the proposal sweeps far too broadly. In PAG's experience, this enhancement could apply in any case where a defendant provided pills that were not directly obtained from a pharmacy. I think you mentioned earlier, we do believe that this reason to believe standard is akin to a strict liability standard that would apply essentially in any case where a pill was not obtained through legitimate legal source, such as a pharmacy, and perhaps even where it was obtained from, for example, a Mexican pharmacy or from a friend who claimed that they had obtained it from a pharmacy. Each of those persons could be subject to the new 2-level enhancement. With regard to the mens rea standard, the department is once again proposing a rebuttable presumption, which I addressed earlier today in the context of firearms. The government proposes that this enhancement should apply unless the defendant can prove by a preponderance that he or she did not know or had no reason to believe that the substance contained fentanyl or a fentanyl analog. Our criminal justice system, again, is based on the government bearing the burden of proof, and the PAG would strenuously disagree with the government seeking to shift its burden of proof in this manner. We believe that that's improper and without legal foundation. We believe that the existing 4-level enhancement adequately addresses the concerns regarding fentanyl pills using an appropriate mens rea standard, and for that reason, we oppose this amendment. With regard to the First Step drug offenses and the safety valve, the PAG supports the Commission's amendment of 5C1.2 to reflect the provisions contained in the First Step Act, including the proposed amendments to the commentary and conforming changes to 4A1.3. As the Commission is aware, since the date of submission of our written testimony, the court has granted cert in Pulsiver. So although we initially requested that the Commission consider amending the commentary to provide that the criteria should be read conjunctively, obviously we now all await the Supreme Court's determination. However, with respect to amendments to 2D1.1b18 and 2D1.1b6, the PAG continues to endorse option 1 and asks the Commission to consider providing guidance in the commentary to these guidelines that as to the applicability of these specific offense characteristics, the criminal history criteria of 3553F1 that are referenced therein should be read conjunctively rather than disjunctively. As the Department of Justice pointed out in its written testimony, the two-level reductions in those sections of 2D1.1 are available in narcotics prosecutions whether or not the defendant is subject to a statutory mandatory minimum and can avail himself of the safety valve. And those provisions serve arguably different purposes than the safety valve. It's the position of the PAG that those reductions should apply as broadly as possible. In addition, the PAG believes the Commission should provide guidance on what constitutes 1-point, 2-point, or 3-point offenses to make clear that those offenses, for the purposes of those sections of 2D1.1, should not include old or otherwise uncountable sentences. If the court, or if rather the Commission, sorry, I'm used to doing arguments, so I was not used to calling you the Commission. If the Commission were to do so, that would make these terms consistent across the guidelines and provide uniformity in application. Thank you very much for the opportunity to provide our testimony.
Thank you, Ms. Kadedu. Ms. Bouchard.
Hey. Good afternoon. Not sure the mic is on again.
I believe you might be able to use that one.
Okay, I'll just go with that. Thank you again for the opportunity to testify before the Commission today on behalf of the Probation Officers Advisory Group. I'm going to talk to you today about safety valve and fake pills, starting first with the topic of safety valve. Due to unforeseen delays since the First Step Act was signed in 2018, districts have been employing different methods to account for the fact that the sentencing guidelines have not yet been amended to correspond with the current version of 18 USC 3553F. The initial issue districts had to address was whether they should continue to apply the guidelines as they appear in the 2018 and 2021 Guidelines Manual, follow that same process, but then account for the reduction by way of a two-level variance, or apply the two-level reduction, treating the current version of 18 USC 3553F as being incorporated into 5C 1.2. POAG supports the proposed amendment as it will resolve that initial ongoing issue. POAG also discussed the possibility of Congress further amending the statutory language under 3553F, leaving again that period of interpretation between statutory changes and guideline changes. Therefore, POAG inquired if the best format moving forward would be to instead refrain from citing the statutory language within the guidelines and simply refer to the statute instead. However, as you are well aware, another application issue remains, and that is the conjunctive and disjunctive analysis in relation to the new criminal history criteria established by the First Step Act. POAG's discussions regarding this matter largely focused on the results in districts where case law follows the conjunctive analysis of the statute. In those districts, examples were discussed in which defendants who have a serious and lengthy criminal history were eligible for safety valve relief, meaning that the reduction essentially no longer applied to defendants who had a reduced criminal culpability. These results are counterintuitive to the intent of safety valve, and resolving that issue was the primary basis that POAG recommended option 2. Some members of POAG expressed concern that procedurally this may become very complicated. With option 2, in some circuits, defendants wouldn't be eligible for statutory relief or the guideline reduction, but in other circuits, defendants would be eligible for statutory relief, but not eligible for the guideline reduction. However, with option 2, the guideline application would at least be consistent, regardless of the circuit within which the defendant was charged. POAG maintains the recommendation for option 2, but we also recognize now that the Supreme Court will soon weigh in on the statutory matter. Another proposed amendment under 2D 1.1 addresses the recidivist penalties pertaining to the definitions of serious drug felony, felony drug offense, and serious violent felony. There have also been questions in prior cases regarding the term a similar offense, and this amendment clearly resolves that issue moving forward. And finally, another proposed amendment under 2D 1.1 is set forth under subsection B13 to add an alternative two-level enhancement for drugs that are represented or marketed as a legitimately manufactured drug. POAG believes that a strict liability type approach is appropriate given the extreme risks associated with having the fentanyl pressed into pill form. The dealer should receive a higher total offense level because of the risks he or she has introduced into the market. Without the proposed amendment, those distributing these kinds of pills aren't being held accountable for the fact that they ignored the potential dangers of distributing such a substance. For victims who suffer overdose or death, the result is the same, regardless if the dealer who sold the pill knew it contained fentanyl. The dealers who distribute these pills take advantage of the fact that the users are under the impression that the pills are safe and legitimate. Along those same lines, POAG also advocates for this enhancement to be offense-based rather than defendant-based, meaning subsection B would begin with if the offense involved, so those who manufacture these pills for distribution are held accountable for their role in the process as well. And then we also inquired if there could be some clarification to the terms represented and marketed and how they're intended to apply. For example, is the fact that the pill resembles a legitimately manufactured pill, is that sufficient, or is more information needed? Regardless of the final decision regarding this amendment, POAG recognizes the harm these pills have on our communities and appreciates the attention to this matter. Thank you.
Thank you. Any questions from my fellow commissioners? Yes.
Thank you so much for your testimony, as always. So I had a question for Ms. Bouchard about the minimum offense level of 17 in Section 5. C 1.2. So I know POAG took the position that the minimum offense level should be kept at 17 in order to keep the gradation between defendants with lower criminal history and higher criminal history. Why don't the guidelines take care of that on their own, regardless? You know what I mean? Like, so Congress didn't want the total punishment to fall below a certain threshold, which used to correspond to 17, but no longer would. Why can't we just keep that floor there and then allow for the guidelines to take care of gradations?
Just keep the 17, why can't we just keep the base offense level of 17, or are you asking should we just create a 24-month minimum?
Right, exactly.
Okay.
24-month minimum.
Yeah, we discussed that. We just didn't see that there was a need to change. We thought the way it was working now was fine. Obviously, more people are going to be eligible for safety valve with the new provisions, and some of them are going to have higher criminal history categories, but keeping it at a minimum offense level of 17 would just account for that and the varied criminal history categories that could present.
DC mate.
Thank you. Thank you both for your testimony today. We really appreciate it. I had one little tiny technical question for you, Ms. Bouchard, on the 2D 1.1 heightened base offense level. It's kind of the same question I asked of the last panel, which is, it sounded like you were POAG is in favor of us adding the language that's there. If we're wanting to make clear that we're capturing the conduct of the charged offense in the 851 context, do you think we need additional language to clarify that, or is what we've proposed sufficient to capture that?
For the recidivist penalties?
Correct.
It's always been my understanding it was offensive conviction based on how the guidelines are currently written. There has been case law on that issue, though, so I think in order to resolve that issue and make it more clear, it would probably be a good idea to clarify that a little bit more within the current language.
Thank you.
The question for both of you. So if we wanted to clarify that our reason to believe, this is in the fake pill context, our reason to believe mens rea standard, if we were to reject the government's suggestion that we shift the burden of proof, but we stick with our proposal and use reason to believe, are there ways you think that we could, specific ways you think we could flesh it out in an application note to make clear that we are not trying to capture, I understand POAG's recommendation, but we, with that recommendation, are not trying to capture everyone? See what I'm saying? So I understand that it is well known in the press, et cetera, that many maybe most Oxy, Adderall, et cetera, pills that are available on the black market contain fentanyl. If we're not trying to capture everyone because of that general knowledge, but we're trying to capture people who, for example, have sold part of a batch of pills with adverse results and then continue to sell the rest of the pills, are there specific factors you think that we could outline to avoid capturing everyone?
I'm not. I think that determination would be so fact intensive that it would be very difficult to set out a set of factors to say this would be an acceptable. This would not constitute a reason to believe, and this would constitute. You'd sort of have to end up having a laundry list of the types of facts that would constitute reason to believe, and it's our position on the PAG that is just it's unworkable and it's going to apply too broadly to everyone, and so we advocate, as you know, for maintaining the current mens rea. I mean, I think the prior panelists noted the Department of Justice has a lot of tools in its arsenal, and there are a lot of enhancements that it can apply, and so it can. I'm not sure why that particular enhancement hasn't been utilized, but it certainly is available, and it can. Elect to pursue the existing enhancements already, and we don't see the need for an additional one.
OAG's position on this has actually evolved a little bit as we've discussed this further, and we are leaning towards the reason to believe isn't needed to be included in the guideline itself. So when we talked about this enhancement, first what we talked about was, do we even need this enhancement in the guideline, yes or no? And POAG supported it being included for the very reasons the DOJ stats indicated and how dangerous it is, and defendants who are selling these drugs need to be held more culpable than the ones who aren't. So after we thought that this definitely was an enhancement we would support, then we focused on how it should be written, and then we just have to think about what kind of facts do we usually have when we see these cases. I mean, it gets manufactured, it goes from dealer 1 to dealer 2, dealer 2 to dealer 3 to user who has an overdose. And what facts do we have when we write the report? So when reason to believe is in there, we need knowledge on what the defendant knew and what they were doing when we write the report. And it's not likely we're going to have that. And I think that's part of the reason subsection A hasn't applied very often as well. So if subsection B is intended to capture this type of conduct, we're leaning towards it doesn't need to be in there. This would just score in circumstances where a drug was sold, had the appearance of being legitimately manufactured, and it contained fentanyl, and then the 2-level increase applies.
Sorry, what would that language look like? Can you say that one more time? You're leaning toward, what's the last?
Of not including the reason to believe provision.
And the language would now be?
It would be if the offense involved a representation or marketing as a legitimate manufactured drug or mixture substance containing fentanyl analog, and it was not a legitimately manufactured drug, that increased by 2 levels. So that's the only two things we would consider when we scored it. Did it appear to be legitimately manufactured, and did it contain fentanyl? Because honestly, when we write these cases, the Department of Justice testified to it earlier, they use code words. You don't have a lot of the information. So if this is intended to account for that behavior, it needs to be written in such a way that we can apply it. And I don't know that we would know defendant's position until we scored it and maybe they objected to it and it was addressed at sentencing.
So just to follow up and clarify then, POAG's position is essentially a 2-point enhancement based on the offense, no mens rea. It's essentially a strict liability. Right. If fentanyl is in the pill or whatever it was, there's 2 points.
Yes.
And if it looks like a
and if it looks like, yeah.
Yep. If those 2 prongs are met, then we would recommend it score.
Would that include anybody who sells it? I mean, anybody who passes it on from one person to the other? I mean, either for sale or for whatever. I mean, I can imagine
that's how
young people giving it to someone, a friend, because they got it from someone, and they all thought it was Percocet, and they've used Percocet before. But this is not Percocet. This has fentanyl in it. So you have one high school kid give it to another high school kid, and the second high school kid dies because of the fentanyl. Would that two-level enhancement that you've been speaking of automatically apply to the person who person A who gave it to person B?
Yes. Yes, I think that's probably a pretty standard practice of how it works. They just keep getting passed on, and if we believe the people putting these in the market are accountable, then we think it's essential to be written that way.
Okay, Commissioner Wong.
Ms. Boucher, can you talk about when you're scoring or when you're preparing pre-sentence reports, maybe you alluded to this a little bit, but why it is difficult for a probation officer to assess that 4-point enhancement that's currently in the guideline? Our previous speaker said, there's all kinds of evidence in a case. Maybe there's a custodial interview where they've acknowledged it. What kind of difficulties or challenges sort of on the ground level have you encountered with?
It's just such a fact-based enhancement. If they knowingly misrepresented and knowingly marketed the substance, so I think with subsection A specifically, they're dealing drugs that they don't necessarily know have been laced with fentanyl. Whereas with subsection B, they're dealing a legitimate pill. Again, they may not know it's got fentanyl in it, but the harm is a little bit greater with subsection B because A is you're buying drugs and you intend to use drugs. B, you're buying what you think is a safe pill that maybe was manufactured and you have that level of trust in the pill that it has a certain amount of drug in it and whatnot, and that's the aggravating factor under subsection B. But like the Department of Justice mentioned before, the amount of information we have on each case varies quite a bit. But with subsection A specifically, that's a case where defendants might not know what they distributed had fentanyl in it.
I know this is a very fact-specific question, but what if the POAG's proposal also included, a caveat that unless the purchaser was aware that the drug contained fentanyl?
They received what they were looking for in terms
Right.
of purchasing it, yeah.
Right.
Is that a less serious offense?
Right, because you were
Right.
acknowledging subsection B addresses a greater harm when someone who unknowingly purchases a pill that contains fentanyl and they thought it was a really cheap, Oxy 30. Do you think POAG's position would change if that were, was the case? If there was clear evidence, sometimes there is a wiretap, and the dealer says, these are great, these are loaded with fentanyl, and the buyer says, oh, great. So I know that's a very specific factual question, but do you think that would be, the harm is a little different there?
Yes, and that's what we focused on when we were discussing this, was the harm is different when you're selling what looks like a legitimately manufactured pill. It's absent when the circumstance that you discussed, when they knowingly purchased the fentanyl, and that's what they were looking for. So that type of a caveat might make sense for this guideline.
Any further questions from this panel? Well, thank you. That concludes our morning. We'll take a brief break for lunch. We will resume testimony in about an hour and 15 minutes or so. Please, let's be in our seats at 2 o'clock and we'll begin the next round of testimony. Thank you all so much for your patience with us today. to start back up after our lunch break. You're in a tough spot, right? Our eighth panel will present the executive branch's perspective on our proposed amendments that seek to resolve conflicts among our federal circuit courts. To present that perspective, we have Carmen Mitchell, who serves as Appellate Chief of the United States Attorney's Office in the Southern District of Texas. Ms. Mitchell serves as Chair of the Department of Justice's Appellate Chiefs Working Group and is a member of the Sentencing Policy Group. Ms. Mitchell has over 25 years of experience as a prosecutor at the state and federal levels in Texas. Ms. Mitchell, we are ready when you are, ma'am.
Thank you. Chairman Reeves and distinguished commissioners, thank you for the honor of appearing before you and for the opportunity to present the Department of Justice's views regarding proposed amendments to Sentencing Guidelines 3E 1.1 and 4B 1.2 to resolve circuit conflicts. First, as to 3E 1.1, acceptance of responsibility, we urge the Commission to resolve the disagreement among the circuits by preserving the government's discretion to withhold a third-level reduction. The guideline currently provides that a court may grant an additional one-level reduction only upon motion of the government. That language came directly from Congress in 2003 through the PROTECT Act. As Congress emphasized, the government is in the best position to determine whether the defendant has assisted authorities in a manner that avoids preparing for trial and permitting the government and the courts to allocate their resources efficiently. The Department supports amending 3E 1.1b to include the framework provided by the Supreme Court in Wade. In accordance with that standard, the government retains the discretion to withhold a motion based on any reason that is rationally related to any legitimate government end, but may not withhold a motion based on an unconstitutional motive. But the Commission should decline to define preparation for trial, as it would not resolve the existing conflict amongst the circuits. Section 3E 1.1b, as amended by the PROTECT Act, does not focus exclusively on the government's interest in avoiding preparing for trial. Instead, it more generally recognizes the government's interest in allocating its resources efficiently. Again, the government is in the best position to determine whether the defendant has timely and sufficiently assisted authorities. Lastly, amending 3E 1.1b to constrain the government's discretion afforded by Congress is unnecessary. If a district court disagrees with the government's decision not to recommend a third-level reduction, the court has discretion under 3553A to vary below the advisory guideline range. I'll next turn to the definition of controlled substance offense in 4B 1.2. The Department urges the Commission to adopt the definition in Option 2. That is, controlled substance refers to substances that are either included in the Federal Controlled Substances Act or otherwise controlled by applicable state law. First, Option 2 is faithful to the current Section 4B 1.2b language, which defines controlled substance offense as an offense under federal or state law. Because 4B 1.2b specifically refers to state law in defining the offense, it follows that 4B 1.2b's definition of controlled substance offense covers offenses involving substances controlled under federal or relevant state law. Second, Option 1 is unduly narrow and would lead to unnecessary complexities at sentencing. If the Commission were to limit the definition to that of the Federal Controlled Substances Act, litigants and courts would have to resort to the complicated categorical or modified categorical approach to determine whether a state drug statute sweeps more broadly than its federal counterpart. Courts have grappled with slight differences between the federal and state drug schedules for cocaine and methamphetamine, for example. Some courts have even determined that prior state convictions involving cocaine did not qualify as a controlled substance because the state definition was categorically broader than the federal definition of cocaine. Adopting option 2 would avoid such complex litigation. The Department urges the Commission to add language to option 2's definition to address timing. The Commission should clarify that the substance at issue must have been controlled at the time the defendant committed the predicate offense. This will resolve the circuit conflict on the issue. Finally, if the Commission amends 4B1.2b to include option 2's definition of controlled substance, the Department recommends that the Commission add the same definition to 2L1.2 Application Note 2 without otherwise changing Application Note 2's definition of drug trafficking offense. This would promote consistency in the guidelines manual. And with this, I welcome your questions.
Thank you, Ms. Mitchell. I now turn to my colleagues. Who've just had lunch, too.
One example of a problem I see on the horizon would be the marijuana laws. So the marijuana are changing all the time in different states. So if we would incorporate the definition including state predicates, wouldn't that lead to some disparities in terms of folks who may have been convicted of marijuana offenses in one state when it was legal then, or in another state where it wasn't legal then, as opposed to just sticking to the federal definition of a controlled substance?
Thank you for the question. It would create unwarranted disparities if we didn't include state law offenses. And that's because there are very minute distinctions from one state to the next or from one state to the federal drug schedules, in that there have been instances where courts have determined that, for example, a state includes ioflupane in their drug schedules. And since 2015, I believe it was, the Federal Controlled Substances Act excluded ioflupane in the cocaine definition because it is medically used to diagnose Parkinson's. And so there are some states, and there's case law that we have cited in our department letter, including out of the Eighth Circuit, where a defendant who actually was trafficking in cocaine does not receive an enhancement in the Eighth Circuit because that particular state statute included ioflupane, and the federal court definition or Controlled Substances Act definition no longer includes that. There were several other examples, and that is out of the Second Circuit. There, the New York statute the New York statute defines trafficking in cocaine to include several substances that are not included in the Federal Controlled Substances Act, such as the drugs HCG and naloxone. Those were included in the state definition, but not included in the Federal Controlled Substances Act. And so the Second Circuit held that the defendant, while convicted of a cocaine trafficking offense, actually did not get the enhancement under the guidelines.
Yes.
Thanks very much for your testimony. Very helpful. I guess one question I have about the government's fallback argument on 3E 1.1, which is that there's no real need to, that courts can be a backstop, basically, when prosecutors are stingy about the third point, is, would that be reversible error? I mean, do you think that courts have, if prosecutors have withheld the third point for something other than an unconstitutional Wade type factor, do you think that would courts be abusing their discretion if they accord the third point even when it hasn't been moved for?
So,
or depart based on that? Yeah.
Right. So you're saying if the court were to vary downward, would that be an abuse of discretion, an appeal from that decision? It would not, because under 3553A, the courts, and in fact the department, looks at the defendant who's standing before the district court for sentencing. And of course, all of those 3553A factors can be looked at to see what the defendant's actual conduct was, at what point was the, with regard to 3E 1.1, at what point was the motion to suppress litigated or the pretrial matters litigated, how lengthy were they, and so again, as you mentioned in the department's letter, we urge that the Congress, through the PROTECT Act, provided the government with the discretion to determine when to move for that third level. And we have to remember that a defendant who pleads guilty still receives, under 3E1.1a, receives the two-level reduction for that acceptance. And so here we're merely talking about the third level reduction and the government determining did the defendant plead guilty with sufficient time to allocate the resources correctly for or appropriately for the government and the courts.
What if the court says on the record, I'm varying downwards solely for one reason, because the government withheld that third point because of a suppression motion, because they had to prepare for a suppression motion?
You know, I think there the circuits would look at what kind of record evidence did the district court place with regard to its decision on 3553A. I'm not sure how the circuits would go if it said that was the sole reason. Of course, right now the majority of circuits hold that it's appropriate because it's not an unconstitutional motive for the government not to move for that third level reduction. And so in the majority of circuits, that would be okay and for the government not to move because it's not based on an unconstitutional motive. Rather, it's a legitimate governmental reason for legitimate government end. And again, that's the allocation of resources.
Yeah.
Thank you for your testimony. What guidance does the Department of Justice give to your U.S. Attorney's offices related to the third level for acceptance of responsibility? Is there a policy? Is there some kind of, guidance? Is it a memo?
Thank you for the question. There's currently not a department-wide guidance memo with regard to the third level reduction again. So if a person's in the circuit that holds one way or the other, they're going to, of course, follow their circuit law. But once this commission, if it determines the decision, makes the decision on this third level, there could be ultimately guidance in the end. But what we do have are district guidance, right? And so there could be in place in certain U.S. attorneys' offices some district guidance on how to proceed. Just currently there's not department-wide guidance because there is the circuit split on the issue right now.
I guess that as a follow-up question, I believe it was in the defender's submission, state that it varies widely, district to district, whether the department moves for the third level decrease for acceptance of responsibility. And so therefore, it's important for the commission to set some parameters or try to give some structure. And so what would be your response to that, where, let's just say if you're in the, Eastern District of Kentucky where I am, they routinely, even if you get to the eve of trial, this is just hypothetical, will move for the third level. Or let's say versus the Western District of Kentucky, where I also sit, that they, almost never, they sort of have a rule. And again, this is purely a hypothetical. But the argument is, I think that it was made in the defender's submission, that it really varies widely district to district, and so that creates a lot of disparity. So how do you respond to that?
Well, the department urges the commission to include the Wade standard by the Supreme Court, again, just saying that it's okay if the government withholds that third level so long as it's rationally related to legitimate government end, and also not an unconstitutional motive. And to that answer to that question as well is, the department urges it's going to be based on the specifics of a particular fact. And so I think it would be difficult line drawing should the commission adopt a definition of preparing for trial. I think that would be difficult line drawing because it's going to depend case to case, and it's going to depend if, for example, we're litigating a motion to suppress. There, it depends on the case where we might have to call victim witnesses, and you're getting the victims involved early in pretrial litigation, or you might be prepping and providing testimony by expert witnesses, and so there's all that preparation to prepare those witnesses to testify. You're doing the legal research and writing for those, and so again, I do think that so long as we rely on the Wade standard, it's constitutional, and it would depend by the defendant standing before trial before the sentencing court and the court itself, the district court.
And I think certainly it's very fact-driven, but I don't think the Wade standard necessarily supplies a standard other than so long as it's not unconstitutional, right? I mean, so there's still no specific guidance from the department to the various districts, U.S. attorneys' offices. Do you understand my point? I mean, because that's pretty wide open, right? I mean, it's basically as long as it's not, there's no unconstitutional motive, that's not really guidance. But I certainly get I understand the point that it is very fact-driven in many circumstances, but I'm just curious to see if there's any guidance that's provided by the Department of Justice.
Certainly Congress, again, provided that discretion. So it's a congressionally afforded discretion to the government, and that's why they expressly stated upon motion by the government. And so that's been since 2003, and it's been workable since then.
Thank you.
Just to follow up on Judge Boo's question, I'm trying to figure out, is there any kind of middle ground here at all? The government doesn't really provide a fallback option to the Wade standard, which is really an unbridled government discretion standard, because it's really stating what's obvious, right? The government can't act unconstitutionally. Is there some fallback formulation of preparing for trial that would provide more guidance, but in a way that's still perhaps more so than the proposal for what that definition would look like, afford sufficient discretion for the government while also some parameters and uniformity?
I do think it would be difficult line drawing. So for the proposal, when it talks about early, again, define early or the term that's used ordinarily. And so I think the proposal still makes difficult line drawing on where is that line, and it just would provide more opportunity for district courts to interpret it differently. And so I think, mostly we're looking at allocation of resources, not simply pretrial matters. And so I think it would be difficult to draw the line between what is early preparation and one of the counter proposals to the proposal, I think perhaps by the defenders, was to make it, instead of time-intensive question, to make it more of a purpose-driven. And I think that, too, is an unworkable solution, because there you're getting into the specifics of the confidential preparations that the government is making.
What about, and just thinking of some ideas, but the government in some other contexts has proposed rebuttable presumptions. And is there a way that you can provide some guidance and uniformity among courts with a presumption that would still leave opportunity in exceptional circumstances where not every case is the same and you don't have a fixed, rigid definition of early, but there's some guiding principles there, and then the government could justify it based on some extraordinary circumstances? I don't know. Is there some middle ground here at all between the Wade standard and the proposal?
I appreciate the question, and the department would be happy to follow up with written testimony on that. However, it really is just about the not constraining the government to parameters such as the defining of the amount of time they've spent on the preparation and at what point. Again, district courts' dockets vary, and so litigating some of these pretrial proceedings are going to vary from one courtroom to the next. And so we would just lean back, certainly, on the discretion provided us by Congress, but certainly I could follow up with some department testimony if there was some middle ground there between the Wade standard and the proposal.
What about pre and post trial? I mean, you could it would make sense of the preparing for trial language, and arguably everything pre-trial happens in the shadow of trial and as you're heading to trial, whereas sentencing, appeals really don't.
Right.
And that's a great line, be easy to administer.
Right, and so as the commission knows, there's a circuit conflict on that as well with regard to sentencing, and what about when there's objections to enhancements and the like, or relevant conduct. And so really the department urges the commission to adopt the majority of circuits that hold that still an allocation of resources, that it's still within the government's discretion to determine how much resources it has allocated in preparing for that challenged sentencing hearing. Oftentimes, let's say, for example, in a fraud case, if there is there's a guilty plea, but there's a challenge to the loss amount or the actual amount, the government is still having to bring victims into the courtroom to testify about the loss amount in a fraud offense. And so it could be that even though there was a guilty plea, at sentencing that could take days with regard to proving up the amount of loss. Likewise with relevant conduct, or some of the case law I read on the circuit conflicts was where a defendant might plead guilty to a drug trafficking but challenges the amount of the drug, right, of course, or perhaps was it tested accurately. And so one of the cases in the department's letter is a case where the defendant challenged the type of drug and the weight, and so the government had to expend resources in getting an expert witness, following the chain of custody to go get it independently tested, and so therein the government is still allocating its resources and spending time on that. So the department urges the position that the majority of the circuits have taken on that issue.
Any additional questions? Maybe you didn't have the hot seat after all. Well, thank you for your testimony, Ms. Mitchell.
Thank you very much.
For those who are just tuning in, we have with us on this ninth panel, Federal Public Defender's perspective. It will be presented again, and we're joined by Michael Caruso, who serves as a federal public defender for the Southern District of Florida. In that capacity, Mr. Caruso supervises over 50 assistant defenders who handle a wide range of cases, including those involving narcotics. Mr. Caruso also serves as chair of the Federal and Community Defenders Sentencing Guidelines Committee. Welcome back, Mr. Caruso.
Thanks for having me back.
All right.
Thank you, Chair Reeves, Vice Chairs, and Commissioners for inviting me to testify again today on two important issues that require Commission action. First, the definition of controlled substance offense in 4B 1.2. The phrase controlled substance offense appears nowhere in the Career Offender Directive or anywhere else in the Sentencing Reform Act. In identifying prior offenses that must trigger a near maximum sentence, 994H refers generally to crimes of violence, then lists 5 specific federal drug trafficking felonies. The phrase controlled substance offense was a shorthand the Commission chose in an attempt to capture the offenses listed in 994H 1B and 2B. Over the years, the Commission expanded the list of controlled substance offenses and explained that even though 994H did not mandate a near maximum sentence for these other offenses, the Commission was acting under its general guideline promulgating an amendment authority. If the Commission has the authority to expand the list of offenses that trigger extreme federal penalties, it also has the authority to contract them all the way down to what is required by the mandate. We are gratified to see that the Department of Justice acknowledges legitimate concerns about the severity levels associated with the guidelines' recidivist provisions, that the career offender guideline in particular has been the subject of considerable criticism for producing overly long sentences, and that decades of research show that the career offender guideline produces a clear racial disparity in its application. We stand together on these issues. Based in part on these joint concerns, the Commission in 2016 called on Congress to amend 994H to narrow the categories of individuals that come within the directive. While the Commission waits for Congress to narrow the directive, nothing prevents this body from dialing the career offender guideline back to the current directive. Given the data and the moral imperative that the guidelines not impose punishments that are unduly harsh and exacerbate racial disparities, the Commission must not wait to contract the definition of controlled substance offense. And the simplest and the most parsimonious way to do so would be limited to those offenses the phrase was originally designed to capture, the federal felonies listed in the directive. We do recognize, however, that this proposal, if adopted, would significantly narrow the reach of the guideline. But as the Commission acknowledged in its 2016 report, the evidence plainly supports this restriction. To do less would be to continue to maintain the unsupportable status quo. If the Commission insists on retaining state drug offenses as predicates, it must limit the definition of controlled substances to federally controlled substances. As we set forth in our written statement, controlled substance has a clear definition under federal law. Expanding the definition to any substance a state elects to regulate would not only vastly expand the reach of this unjustifiable guideline, but it would do so with no clear limiting principle and spawn litigation. The second guideline that requires Commission attention is 3E 1.1, acceptance of responsibility. We asked the Commission to clarify two aspects of this guideline. First, we agree with the Commission that you should clarify the term preparing for trial. Second, the Commission should slightly revise the existing commentary at Application Note 6 to clarify that the government should not withhold the third level for interests not identified in 3E 1.1b. I described in my written statement how the 3E 1.1b motion is being used by some prosecutors on the ground. How despite the guidelines' plain language and the Commission's clarifying efforts, some prosecutors still withhold or threaten to withhold the 3E 1.1b motions for reasons far beyond obtaining a timely plea and avoiding a trial, for leverage. These reasons include for legitimate and critical conduct that occurs post-plea, such as ensuring a person's right to be sentenced on accurate information by challenging unreliable or incorrect information in the PSR. Prosecutors also threaten to withhold the 3E 1.b1 motion for pretrial litigation that has nothing to do with trial and seeks to vindicate our clients' constitutional rights, including for motions to dismiss for lack of jurisdiction, to move to suppress for evidence unlawfully obtained, and for ask for discovery regarding exculpatory evidence. This conduct is critical to ensuring that our clients' rights are protected and that any subsequent conviction, whether by plea or trial, is warranted. We've asked that the Commission focus its examples of pretrial work that does not constitute preparing for trial on the purpose of that work and not on its timing. In other words, a functional approach. And I want to offer some additional context of why that is important. As public and community defenders, our clients never choose us. A judge appoints our clients to us. We meet them on one of the worst days of their lives, invariably in court or in jail. Our clients must get to know us, to trust us, have confidence in us, and be able to discuss the details of their case and life-altering options with us. In many of our cases, it's about our clients choosing the least worst option for them. If we are doing our job right, that takes some time. None of the changes defenders propose would alter the meaning of 3E 1.1b or amend the scope of the government's discretion to move for the third level. These changes would merely confirm what should already be clear, that the government's discretion to withhold the third point must be exercised within the guidelines limits and should not be used to prevent good faith litigation unrelated to timely pleas. I welcome your questions. Thank you.
Thank you, Mr. Caruso. Commissioner Blisky.
How are you? It's good to see you again.
Good to see you again.
I've got a couple questions. I just want to clarify what I just clarify what you said. Were you suggesting that you're asking the Commission to say that for a prior controlled substance offense that the person must be convicted of a federal statute? Is that sort of your lead position, and then your fallback is just described in the federal law?
So our lead position is that the plain language of the statute and ordinary canons of construction dictate that only federal offenses count and not state offenses. And we could walk through that if you like.
I kind of would, just for a second, because the Congress didn't say that you were in 994, I think it's H, that the person was convicted of these statutes. It says it was convicted of an offense described in these statutes. So yes, walk me through how that becomes.
Right. So earlier this morning I described my simple education, and maybe this is part of that as well as the way I read this statute. So 994H2B uses the same described in language as 1B. And 1B is the federal triggering conviction, correct? So in 1B, it uses described in to clearly delineate only federal convictions. So using the same phrase in the same statute, the canon of consistent usage means to me that they mean the same things, right? So using it to described in to refer to only federal convictions in one subpart, and using that same phrase in a subpart indicates to me that Congress meant the same thing. And if you look further down in the statute, after H comes I, of course, and in I, Congress specifically denoted federal, state, and local offenses. So my memory is not great, but what I generally can remember is the sentence I wrote immediately preceding the one I'm writing now. So it seems odd to me that Congress would write H in a way that conforms with only federal convictions, and then in the very next sentence spell out federal, state, and local if they meant the same thing as described in.
Got it. Okay. Can I ask one other question, and that is, if the commission sticks with the policy that it's had up until now, which is that state convictions, in some respect, whether that's in the career offender, which is the statute that we're talking about, or elsewhere in the guidelines like 2K, that uses prior convictions for controlled offense, it seems to me that the problem that we're having is because of this intersection between the definition of controlled substance, but also the categorical approach. So if you have someone who was convicted in state court of selling cocaine, which is on the federal list, but because the state list may include something else that's not on the federal list, all of a sudden that doesn't count as a prior because of the categorical approach, not necessarily because of the definition. First of all, am I getting that right? And is there a way for the commission to say, okay, we'll focus on the state, on the federal crimes and the federal controlled substances, but we'll get rid of the categorical approach so that if in fact you've trafficked in cocaine or heroin or fentanyl or anything on the federal system, regardless of what the state law encompasses, that's going to count. I know that's a two-parter.
So, and yes, I'm gonna do this thing where, as to your first part, hopefully we can address that in our post-hearing comments. Okay. But as for the second part, I can forcefully say that the defenders are believers in the categorical approach. You know, as a longtime trial lawyer now, my experience tells me that the only thing we can determine by a plea or conviction or what the elements showed, right? Because even in federal court, when the assistant United States attorney proffers something to the court out of a change of plea hearing, there are always these strategic and tactical decisions to make, as like, do I push back up against that? Do I not? You know, ultimately keeping our eye on trying to get our sentences a fair and just sentence. So we would continue to ask the commission to rely on the categorical approach and not deviate from that.
So you think we should import the categorical approach here? So for like the department head, I thought was a compelling example about cocaine being amended in 2015 to federal cocaine to no longer include iuflopane.
Right.
ioflupane, and a vast number of state statutes prohibiting cocaine still including ioflupane. And so in those states, you think that cocaine should not be considered a controlled substance.
Right. Our first position is that no state conviction should count.
Yeah,
But of course,
yes,
if the commission decides state offenses should count, then yes, we would ask the commission to adhere to the categorical approach.
And do you think it makes policy sense for cocaine not to count as in a large number of states not to count as a controlled substance?
So I think, and I'm not trying to be flip, I think the answer is that no drug conviction should count under the career offender guideline. I mean, this body's own research has shown that. You wrote a pretty blunt assessment to Congress to undo that. And I think at bottom what the defenders are saying, like every problem is an opportunity in disguise. And I think that's what we can do here. If we consider a circuit conflict a problem, then I think, as I said in my written testimony and my statement today, I think the commission can use this opportunity to narrow the career offender guideline, which, as you know, judges vary 80% of the time, that it's not a good indicator of recidivism, that it goes far beyond what the Senate originally intended for drug offenders. So I think it does make good policy.
Mr. Russo, can you go back to what you had said earlier? Can you just repeat what you had said about attempts to get Congress to, you said something about amending 994H and not.
So my understanding, I mean, the staff here is in the best position to know this, but my understanding is that this commission has urged Congress to amend the career offender directive to be able to exclude at least a certain category of drug offenders from its reach.
But in the backdrop, I appreciate the candor of your testimony because you were sort of laying forth that what the defenders are proposing now would be a significant narrowing of what has been the reach for a long time. I guess absent some kind of congressional change here, what would be, we've had this status quo for a long time and Congress has not made these changes, and what are we to make of that?
So I think we have to go back to first principles, and in my answer to Commissioner Wroblewski's question about 994H, I think it's a simple statutory construction issue. I don't know what led the commission to have these rules that have been the status quo, but I know time and time again in our nation's history, like we have stepped back and looked at past practices and said, is that the best practice? Is this the best reading of this law or statute? We know the Supreme Court has recently overruled cases that had been long-standing precedent. So I think if you go back to 994H and just look at the statutory construction of that statute, how they use the same terms and how that's been interpreted to mean different things, how another subpart of that statute is more explicit about describing when Congress wanted state, federal, and local offenses used, I think you can rationally come to the conclusion that the statute has been wrongly read in this context for a very long time.
Thank you for your second round of testimony today. I appreciate it.
Be gentle.
I'm going to go back to acceptance of responsibility for a second. Our data show that the vast majority of individuals who receive acceptance of responsibility get the 3 levels. So it's a small handful of people who are kind of in that range who aren't getting it. And, the government has suggested this kind of fallback argument of relying on variances. Are variances sufficient in this context with acceptance of responsibility in that third point?
So, as a trial lawyer for over 20 years, and I have to say most of my cases is resolved by plea, and of course led to sentencing. Most of my trials have also led to sentencings. So I think this is, an area that not only am I familiar with, but every defender is familiar with. And I think to answer the first part of your question about, and I haven't seen that data, but I assume it to be true, that there is a small percentage of people who don't get the third point, and like the commissioner, defenders are believers in data, but I think there is a data gap in this particular circumstance, because as I alluded to in my opening remarks, this is about leverage, right? We're all lawyers here, and in the civil context and certainly in the criminal context, lawyers seek to exert leverage to get the resolution they want. And I think I pointed out an example from my district in these maritime drug trafficking cases where the AUSA, who prosecutes those cases, was fairly straightforward. If you file a motion to dismiss for lack of jurisdiction, which again, Chief Judge Pryor wrote that decision, giving us that framework, and go to an evidentiary hearing, she would not file the motion for the third point. And in addition to that, would not agree to a conditional plea. And I think that's just wrong. I mean, again, a lot of these pretrial matters are lawyer-driven decisions, right? My clients don't generally have a knowledge of criminal court's jurisdiction, Fourth Amendment law, Brady, Giglio, discovery, due process law. These are issues that we assert on behalf of our clients that are constitutionally based. And part of that also harkens back to what I said earlier about developing this relationship with your client so your client can trust you. So when you're saying, I know like both door A and door B are bad, but I think you should go through one of those draws, they know that we've worked exhaustively to try to get them the best outcome. That being said, lawyers and our clients are risk averse. So when standing in the face of a threat to withhold the third point, a lawyer may, I don't want to be derogatory here, but cave, because, I think as Justices Sotomayor and Gorsuch said recently in the Fifth Circuit case, that 1 point can mean a tremendous difference in our client's life. At the low end, it might mean the difference between going to prison and not going to prison. At the higher end, it could mean years in prison. I don't think a judge's decision to vary down should really, I think this law and this guideline is fairly straightforward, and we shouldn't have to rely on the judge to sort of undo what the government has chosen not to do.
Is there a point where the defendants may agree or concede that the government has been pushed too far to give the point? Jury selection, maybe, but of course, a defendant can learn a lot during the jury selection about his case. So, is there a point?
Right, and I'm not going to try to dodge your question. All of these are fact driven, but I think, of course, there can be cases where, under our reading of what the guidelines should be, that the government could legitimately withhold the third point. Certainly, we're not asking for sort of a strict liability ruling that the government always has to file the third point if the client please. But we want more. We want more clarity. We want a functional approach to this. That sort of we're putting the government to their burden of specifically preparing for trial. And I think, the examples given, motions in limine, jury instructions, and matters like that come much, much closer than filing a motion to dismiss or a motion to suppress.
But nothing requires a party to wait 14 days to file their motions in limine, right? Motions in limine can be filed whenever, right? Can't they?
Right. That's why. Right. That's why. And in my experience, sort of, I think one of the secrets about criminal law is that there are various categories of cases, and the various categories have certain defenses that we raise, and the prosecutors have certain rebuttals. So most of the time, there's not a tremendous amount of work because a prosecutor in this type of case knows this motion in limine should be filed, these jury instructions should be filed. In fact, in my district, I'll give Judge Middlebrooks a shout out. He was a proponent of this jury instruction builder. I don't know if that's in any other districts, but generally you just start checking boxes and it emails you a set of jury instructions. So that even in our district, that doesn't take much time. But we wouldn't want to focus on the early preparation that could be seen relevant for trial for two reasons. Districts vary in the pace in which they operate. I come from a rocket docket, so we have to move very quickly. But just because a prosecutor, because he or she wants to get ahead of the game, drafts a motion in limine, 2 weeks after arraignment, we also don't think that should bear on, either the government's decision to file for the third point or the judge awarding the third point. Okay, and I haven't been asked a question about this, so but I know a previous witness had been asked about the Wade standard. Defenders absolutely disagree that the Wade standard should be used, and if there are no questions about that, we'll fully brief that in our post-hearing comments.
Okay. Thank you, Mr. Caruso. Do we need to get you some more water?
I think they're...
We'll make sure we get...
Go ahead. I got some, but I may not have left my compatriots with enough. Thank you.
Our 10th and final group of panelists for today will provide us with perspectives on this issue from two of our advisory groups. First, we will hear from Marlo Kadedu, who serves as the Fifth Circuit representative to the Sentencing Commissioners Practitioners Advisory Group. Ms. Kadedu is a solo criminal defense practitioner who handles federal cases across the nation. Ms. Kadedu has previously served as a steering committee member of the American Bar Association's Death Penalty Representation Project. I say all that again for those persons who are just joining us. Second, we'll hear from Ms. Jill Bushaw, who serves as chair of our Probation Advisory Group. Ms. Bushaw serves as Deputy Chief United States Probation Officer for the Northern District of Iowa. She joined the U.S. Probation Office in 2003 and has previously held positions as a sentencing guideline specialist and as a supervisory and assistant deputy chief in the pre-sentence investigative unit. Finally, we'll hear from Professor Mary Graw Leary, who serves as chair of our Victims Advisory Group. Professor Leary is the Senior Associate Dean for Academic Affairs and a Professor of Law at the Catholic University of America. Professor Leary has previously worked in a range of positions in the criminal justice system, including as an Assistant U.S. Attorney for the District of Columbia, as the Director of the National Center for Prosecution of Child Abuse, and as Deputy Director in the National Center for Missing and Exploited Children's Office of Legal Counsel. We have these ladies before us, and we'll begin with Ms. Kadedu.
Thank you, Judge Reeves, Vice Chairs, and Sentencing Commission. We appreciate very much the opportunity to provide the PAG's views on circuit conflicts. The PAG, as we've discussed, is comprised of private practitioners who represent criminal defendants in the federal criminal system. I'm going to start, with your permission, with 4B 1.2 and the definition of controlled substances offenses, because I have more to say, I think, for 3E 1.1, so I don't want to run myself out of time. The PAG supports the Commission's proposed option 1, which defines controlled substance as those substances identified under the Federal Controlled Substances Act, 21 USC 801. This definition provides a straightforward framework for analyzing whether a defendant's prior conviction is a predicate offense for purposes of the career offender guideline, and it will promote uniformity in sentencing law across the country. In contrast, the PAG believes that the second option's use of inconsistent state law definitions of controlled substances offenses will increase unwarranted sentencing disparities among similarly situated defendants nationwide. Under option 2, two defendants convicted of the same offense with similar criminal records may be subject to vastly different guideline ranges depending on the state in which he or she is prosecuted, and we have a couple of examples. I never can say this. Cannabidiol, CBD, cannabidiol, has been legal in Wisconsin since 2014. Thus, a defendant's pre-2014 CBD distribution conviction would serve as a career offender predicate, even though CBD is legal both in Wisconsin and federally. Such a conviction is not a proxy for dangerousness or recidivism, given that state and federal governments have legalized CBD. Hemp is another good example. In 2018, the government removed hemp from the list of controlled substances, and as of 2020, all states except for Idaho have legalized hemp. If state law is used to determine the definition of controlled substance for purposes of the career offender guideline, an Idaho conviction for hemp manufacturing prior to 2021 would be categorized as a predicate offense. This is so even though this conduct is now legal in Idaho and was legal across the country at the time. Whether a defendant is subject to the enhanced penalties under the career offender guidelines should not depend on an accident of geography. The sentencing implications for the second option are especially troubling given the astronomical increases in sentences for career offenders and the fact that between 2016 and 2021, 75% of defendants sentenced as career offenders were people of color. The PAG believes that adopting the second option will undermine the uniformity that the guidelines strive to promote and could exacerbate unwarranted race-based disparities. Now, with regard to acceptance of responsibility, the PAG endorses the Commission's proposed amendment to resolve the circuit conflict that has arisen regarding whether the government may withhold the third point for acceptance of responsibility, with one addition that I'll mention in a moment. The PAG's experience with this issue varies widely across the country. In some districts, the government rarely, if ever, withholds motions for the third point of acceptance. In other districts, practitioners face a dilemma over how to advise clients who may have grounds to file a motion to suppress or file substantive sentencing objections, but by doing so may face a penalty at sentencing, namely the loss of the third point. Importantly, requiring defendants to forego filing suppression motions in order to obtain the third point insulates law enforcement misconduct from judicial oversight, and of course it has constitutional implications. This amendment thus will serve the important salutary purpose of promoting the integrity of the criminal justice system. Accordingly, the PAG welcomes the Commission's proposal to clarify the circumstances when the third point may be withheld by defining the term preparing for trial, but we do have one request regarding that definition. The PAG suggests that this definition be further modified by replacing the term drafting in the second sentence with filing. The PAG believes that this minor modification will limit litigation about whether an action is in fact preparation for trial and will facilitate district court's ability to make this determination, since the docket sheet will reflect what has been in fact filed. I wanted to mention for a moment the Department of Justice's statement said something about how the court can, if the court disagrees with the decision to withhold the third point, the court can vary from the guidelines. And I would contend that this, what they call in film fixing in post, is really not the way that we should go about taking care of this issue. That will lead to disparate impacts. In my circuit, for example, 60% of guidelines are or 60% of sentences are within guideline sentences, and those guidelines are, in fact, the default. And so this idea that judges willy-nilly will depart to fix this issue is just simply not going to be the experience in every circuit. So with that, I see that my time is up, and I will pass the floor.
Ms. Bouchon.
Good afternoon again, and thank you for the opportunity to speak on behalf of the Probation Officers Advisory Group. I'll start with the acceptance issue. There are numerous issues before the Commission this amendment cycle, but the proposed amendment to acceptance of responsibility is capable of having the broadest impact. Whether an acceptance reduction is applicable is a guideline finding the court makes in every single federal case. Ideally, straightforward application principles would be characteristic of such a universally applied guideline. The Commission heard testimony during 2018 regarding whether objections at sentencing jeopardize the defendant's eligibility for a 2-level reduction for acceptance of responsibility under subsection A. The issue before the Commission today is how those exact same objections can impact the defendant's eligibility for the additional 1-level reduction under subsection B, as well as the issue of pretrial suppression motions. POAG observed the overlap of this issue and believes such an amendment to this guideline would help clarify if issues such as suppression motions and sentencing objections are a relevant factor under subsection A and or subsection B. POAG believes such a clarification is essential as the parties have indicated they rely on the potential impact of an acceptance reduction early in the case and prior to the plea, but also at the time of sentencing, and will need sufficient notice of how this guideline is intended to operate. With regard to whether suppression motions and sentencing challenges impact eligibility for acceptance of responsibility, POAG observes there are opposing positions on this issue. On the one hand, POAG defers to the government's position regarding the amount of resources required to prepare for a suppression hearing or address sentencing challenges. The government is in the best position to articulate that issue. On the other hand, POAG defers to the defense's position regarding the suppression motions and sentencing challenges that they did not pursue after discussing with their client the potential risk of losing an acceptance reduction. The defense is in the best position to articulate that issue. But how does our system handle instances where there are opposing positions regarding suppression motions and sentencing challenges? We present the issue to the court. The court holds a hearing on the contested matter, the parties present their evidence and make their arguments, and the court makes a finding. POAG believes it's essential that both parties have the same opportunity to argue their position with the same amount of aggressive effort and without the concern for collateral consequences. Therefore, POAG supports the proposed amendments to 3E 1.1. The other circuit conflict the Commission is seeking to resolve is the definition of controlled substance. POAG first observes that the pending amendment related to the listed offense approach is an alternative process to this pending issue. But in relation to this issue, though, option 2 includes state-controlled substances, but the means and elements of those state offenses may not be covered by a Chapter 2 guideline under the listed offenses approach, because those guidelines only pertain to offenses covered by the Controlled Substances Act. Therefore, POAG inquires if the listed offense approach effectively adopts option 1 as the definition of controlled substance, or if there is at least an argument that such is the case. The members of POAG who favored option 1 had concern that option 2 does invite some disparity into the federal process by relying on the various controlled substances that could be charged in each state. Those state offenses will still qualify as prior criminal convictions in determining their criminal history category, but under option 1, they wouldn't be used as a basis for career offender or an increase to the base offense level. Given the variance rate related to career offender, especially when the predicates aren't based on a crime of violence, some members of POAG thought this would be a good opportunity to address that issue while staying true to the perceived intent of 28 U.S.C. 994H, that the sentencing guidelines provide for an increased sentence when the predicate involves substances involved in the federal system. However, a majority of POAG favored option 2, as the identified goal of this proposed amendment is to resolve a circuit's conflict. Option 2 maintains the current practice within a majority of the circuits. It accounts for the defendant's increased level of culpability for knowingly distributing an illicit substance. It resolves concerns that a state-controlled substance offense would be deemed overly broad and categorically wouldn't qualify. And most importantly, it relies on the longstanding definition that controlled substance includes both state and federal law. Thank you.
Good afternoon. The VAG appreciates the Commission inviting us to discuss on the one issue that we are going to address, the circuit conflict regarding 3E 1.1, acceptance of responsibility. Let me begin by saying the VAG really appreciates what the Commission seems to be trying to do to sort of, on the one hand, balance the Congress's directive that the government is in the best position to determine whether a defendant has assisted authorities in a manner that avoids preparing for trial and allocating resources efficiently, as well as Congress's directive that an adjustment under this subsection may only be granted by the government's formal motion, and the idea that, of course, we don't want prosecutors to refusing to make this motion for unconstitutional motives. However, the VAG opposes the method that the Commission is using to address this issue for three reasons. First, the proposed amendment does not achieve the stated purpose of clarity. Second, its language is so broad that it categorically precludes appropriate withholding of 3E 1.1b reduction, which is a decision best left to a case-by-case analysis. And third, the breadth of this language fails to consider the victim experience of several pretrial motions, and it risks harm to victim interest. First, the proposed amendment does not serve the purpose it states. It doesn't provide clarity. The purpose of 3E 1.1b, is to allow the government the discretion to move for a one-level reduction if the defendant has been timely, permitted the government to avoid preparing for trial, and permitted the government and the courts to use its resources efficiently. The amount of work necessary for trial or a motion preparation varies from case to case, as has been discussed already, and only the prosecution knows the work that it's done in preparing for these motions or preparing for trial. The proposed amendment denies the government this discretion, congressionally mandated discretion, in direct opposition to Congress's text and purpose, and it doesn't provide clarity. It doesn't provide clarity because the definitions proposed are too broad, and they propose a categorical approach to a case-specific issue. Whether the government had to inefficiently allocate resources to prepare for motions turns on a substantive questions: the type of case, the type of motion, the witnesses involved, the legal research necessary, the preparation needed. But the proposal suggests that this determination is best made not by a fact-specific inquiry, but by applying phrases such as actions taken close to trial or early pretrial proceedings. And that's unworkable in our view for two reasons. First, it's vague and subjective. But secondly, it's choosing a temporal measure for determining whether a pretrial motion demands similar resource expenditure to preparing for trial. And that's simply not an accurate measure. How many resources were expended in the measure of this can happen early in the process, or later in the process, something could not require a lot of preparation. But most importantly to the VAG is a third reason that we oppose this motion, and that is it ignores the victim experience. Some pretrial motions involve the direct participation of victims or witnesses. They might have to prepare to testify themselves, or work with the prosecutor to prepare for the motion, or be re-traumatized by the very fact that the motion is being filed, all of which require resources of the government, prosecutors, advocates, law enforcement. But more troubling, certain kinds of cases, sometimes we regret to say our observation has been the defense is simple. Put the victim through re-traumatizing pretrial motions, which are designed to dissuade the victim from continuing to participate in the trial process. Examples of this could include discovery of personal medical records, seeking psychological records, etc. And let me be clear, we're not saying that's always the motion, but our experience in working with victim survivors across the country is sometimes it is. And should the prosecution successfully keep the victim survivor on board through all of these re-traumatizing motions to be ready for trial. The defendant should not then be able to claim acceptance of responsibility. And in our view, the government is well within what Congress intended to refuse to file the motion for an additional deduction because of the trauma the victim or witnesses have experienced, which required significant expenditure of resources on the part of the government to continue to trial. This is a matter that by design is for the prosecutor to determine. And because the proposal does not add clarity, it is a blunt instrument and it ignores the victim experience, the VAG opposes it. Thank you very much.
Thank you. I now turn to my fellow commissioners, see if there are any questions of this group. Commissioner May.
Thank you all for your testimony again by every single one of you. I appreciate you coming back. I have one question, Ms. Bouchard. In your written testimony, you talked a little bit about the relationship between this proposed amendment and the acquitted conduct proposed amendment. Could you address that a little bit more? I just wanted to make sure I understood what the POAG's position was on those two together.
Sure, I'd be happy to. I testified on February 24th of 2023 that POAG didn't have any concerns about acquitted conduct being used against a defendant at the time of sentencing, just like any other type of relevant conduct, because there's due process available at the time of sentencing. And the type of objections that they're going to have to relevant conduct, acquitted conduct is most likely going to be disputed at the time of sentencing compared to others. But that testimony was based on probation office perspective and experience. So we sit through hearings, we talked about this at our meeting, and it's our observation of the process that everybody gets to kind of object to what they want to. We see plenty of objections from defense, we see plenty of objections from the government, and so I was comfortable with that, but the next morning started working on my testimony for today, and then when you start reading cases, there's case after case after case where a defendant loses acceptance for doing that very thing and asking for acquitted conduct to be approved at the time of sentencing or any other type of relevant conduct. So just the interrelation to these two, we just thought it would be appropriate to point it out. It doesn't change our position on acquitted conduct because we still think it's largely, defense are largely able to approve that or have the government prove that at sentencing, but it just became apparent that maybe that body of case law out there that says that they could lose that has an impact on defense that probation wouldn't necessarily be aware of. We wouldn't be aware of what they would have done had that case law not existed.
Can I follow up though? So you see many pre-sentence reports. Are did most of those include some defense objection? Very few of them include a defense objection? Because the data that we see shows that the vast majority of cases where a defendant pleads guilty gets 3 points. And I get it. I get especially Mr. Caruso's concerns that you're, I think, reflecting, which is if no one was objecting, there might be a chilling effect. So everybody's getting the 3rd point, but they're not objecting because they're afraid that they won't get the 3rd point. But I'm curious, in the cases that you see, the pre-sentence reports that you write and then circulate and then bring back, do most of those include objections or not include objections?
Several objections from both parties. And we talked about this at our POAG meeting just to make sure, because of course you can't testify to what happens in every case in every federal court. There are always exceptions, but we went around the room and generally, as long as there weren't objections to plea agreement stipulations or elements, there was a perception that defendants could object to as much as they needed to at the time of sentencing. But again, that would be our perspective because we aren't aware of what would have been objected to or what would have been brought forth to the court to address.
Thank you.
I actually have a follow-up on that. Bounce back and forth. And maybe this is too long a time period because it's been a while since the commission last amended that acceptance of responsibility provision, and you addressed that, and that kind of went to some of those non-frivolous, I can't remember what the words were at the time, but those challenges. Has POAG noticed a change in objections since the commission amended that guideline in 2018. maybe?
Yeah, it was 2018. That was one of the comments we had in 2018 was if to make sure whatever is changed in this guideline, it's significant enough that it has an impact on the case law. We didn't discuss that as a group, but just the fact that it's on the agenda again makes me think it didn't have the effect of making a big change on the case law, that edit from 2018.
Any other questions of this panel? Ms. Leary, I do have just a couple of questions. You indicated that you thought the language that we've put out there is too broad. And I know in other instances, panelists have come back with differing language or suggested language. Is there language that you can provide that might narrow it? And the same question with respect to doing it temporally as we've done it. Is there a suggestion as to, well, how should we do it?
I'm going to take the second question first to say I just think temporally doesn't get you where it seems that the commission wants to go, just because every case is so different, and front end, we've heard discussion about building trust. Try building trust with a victim who's been traumatized by violent crime. That has to happen early and takes a long time in order to get to the place where they can, in front of 12 strangers, describe the worst thing that's ever happened to them. So that starts really, really early as well. So I don't think temporally is the way to go. I'm happy to submit to writing some alternative language at the invitation of the commission after talking with our advisory group. I would offer a way of thinking about it, but if I could put on my law professor hat and take off my chair hat, which means everyone's going to fall asleep and start getting on their phones, but hopefully that won't happen. I think that it's very clear from the text that Congress intended this discretion to be for the government. That was what it was intended for. And I think if the commission wanted to reframe this to think about what's called what I've labeled, again, I'm speaking almost individually, as structured discretion, right? So guiding principles, but the discretion is still with the government. I think that is an avenue to go. I'm happy to bring it back to the victim advisory group to get sort of the group sign-on on that. But it's a principle. Academics are the worst because they hawk their own wares, but this is a principle that I've written about in a couple law review articles, and I don't mean to talk about just myself, but that's sort of the idea is discretion. But if there's agreed upon sort of points to consider beforehand, it can limit something wide open, or like Commissioner Wong was discussing, something between Wade and absolute discretion. So I'm not dodging your question. I'm happy, but I'm hesitant to speak from the whole group on that specific alternative language because we didn't reach any to suggest to the Commission.
Thank you. All right, I guess tomorrow everybody's going to want to be on the afternoon panel. Ladies and gentlemen here and those who are online, we appreciate you for spending this day with us because this here closes our third day of testimony. And on behalf of my fellow commissioners, I want to thank each of our panelists, those who remain here, those who have gone on to your other duties. I do thank each of you immensely for spending this day with us, providing your testimony, and where needed or where desired, if you wish to supplement your testimony, we just ask that you do so by March 14th. We will be back tomorrow at 9 o'clock a.m. to receive testimony on our proposed amendments regarding the career offender guideline and the use of criminal history scores. I look forward to seeing every one of you then and hearing those who might be on the line. But thank you so much for spending this day with us. We are now adjourned.